interpreter that I have to take as soon as possible on Zoom on her case. Oh, great, thank you. This is going to be number 2 on the transport list. Let me make sure I've got the interpreter first. Yes.
Doobie said he just checked and he said we're good.
Okay.
Because we're 0135, but we're subsection 3, and he said it's subsection 5.
That's what I was thinking, I did look at it. Okay, good.
Judge, I stepped out. Were you taking the interpreter case first?
Yes.
Thank you, ma'am.
Assuming the interpreter is in the waiting room, and I'm trying to figure that out. I believe we do have the interpreter in the Zoom waiting room.
Should be, yes. Mr. Bellamari?
Yes.
Yes. That would be my interpreter, Judge.
All right.
Brandy Merrifield on behalf of Kalisha Gulakante, it's 25 CF 2069.
Okay, just 1 second. I'm having some problems with Zoom.
Okay.
The interpreter is no longer in the Zoom waiting room.
May have lost connection. I'm happy to wait if they pop back in. Judge, would you like us to just take a moment and?
Yeah, the interpreter was just there.
Perfect.
Before I could bring them in, they disappeared from the Zoom waiting room.
That's okay, Judge. We can bring Mr. Gulakante back as soon as the interpreter shows up.
Okay, I guess it'll be any minute.
Yeah, that's fine. Thank you,
Okay.
ma'am.
Oh, is that, the interpreter's back.
Okay, we're back.
The interpreter's back.
Okay.
So,
Alicia.
Okay.
Sometimes it's a Monday every day of the week, Judge.
so sorry?
I said sometimes it's a Monday every day of the week.
Oh, yes.
All right. So Brandy Merrifield on behalf of Kalisha Gulakante and 25 CF 2069. And Judge,
Waiting for the interpreter to, the Zoom is having some problems.
yes, ma'am.
So, the interpreter's trying to join us. And just as soon as,
Can you hear me?
yes, good
Oh,
morning.
thank you.
This is Judge Clark.
Good morning, Judge. How are you?
Great, thank you. We are not
Of course you-
able to see.
Oh,
There
can
we
you see
are.
me now?
Yes, thank you.
Of course.
Let me swear in, Madam Interpreter.
Yes, Your Honor.
Do you solemnly swear or affirm that you will make a true interpretation to the witness of all questions or statements made to or by him in a language which the person understands, and a true interpretation of the witness's statements into the English language?
I do.
Thank you. And if you'll just state your name and spell it for our court reporter, please.
Yes. Nilotpally Velamuri. NEELOTHVELAMURI.
Thank you so much.
Yes, Your Honor.
Thank you, Judge.
Yes.
Brandy Murrayfeld on behalf of Kalisha Gulakante. Case number is 25 CF 2069. We have reached an agreement, if I may approach.
Yes.
మేము ఇప్పుడు మీ కేసు విషయం పిలుస్తున్నారు. ఇప్పుడు మేమిద్దరం ఒక నిర్ణయానికి వచ్చాము. మీ దగ్గరికి రావచ్చా అన్నారు. ఎస్ రండి అని చెప్పారు. మీకు వినిపిస్తుందా?
And in Mr. Gulakante's case, he's withdrawing his previously entered not guilty and entering a no contest plea.
ఇంతకుముందు మీరు నేరాన్ని కొని చేసిన విషయం అది ఆ ప్లీని మీరు మార్చేసి నో కాంటెస్ట్ అని చెప్పేసి చెప్తున్నారు అని చెప్పేసి మీ వకీల్ గారు జడ్జి గారికి చెప్తున్నారు.
In exchange for the plea, counts 1 and 2 will be dismissed. Count 3 will be sentenced as follows.
దానికి బదులుగా 1, 2 డిస్మిస్ చేసి మూడో కౌంట్ని దానికి ఇలా శిక్షిస్తున్నారు. దానికి ఇలా చెప్తున్నారు.
Count 3 is as charged, 60 months probation, $40 per month cost of supervision, $518 in court cost, and no unsupervised contact with any minors, and not in a place where minors congregate.
సో చిన్నపిల్లలు కలిసే చోట ఉండకూడదు, చిన్నపిల్లల్ని ఎటువంటి సంప్రదింపులు పెట్టుకోకూడదు. 60 నెలలు మేడం కౌన్సిల్, ఇట్స్ 60 months probation, కరెక్ట్?
Correct.
ఓకే, 60 నెలలు ప్రొబేషన్, నెలకి $40 మీరు వాళ్ళకి మీ కాస్ట్కి ఇవ్వాలి. $518 కన్నా మించకూడదు. అది మీకు మీరు ఒప్పుకున్న కండిషన్స్కి.
And this will be an adjudication, Judge.
ఇది వాగ్వివాదాల తర్వాత అడ్జుడికేట్ చేయబడింది అని చెప్తున్నారు.
All right, sir, if you will please raise your right hand.
కుడి చేయి పైకెత్తండి.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
మీరు చెప్పేదంతా నిజం అని చెప్పేసి ఒకవేళ మీరు నిజమే చెప్తున్నానంటే ఐ డూ అని చెప్పండి.
Thank you. You can put your hand down. Could you please state your name?
My name
మీ పూర్తి పేరు చెప్పండి.
Gullakanti Kalesha.
If you could get near the microphone and just repeat that one more time. There we go.
Gullakanti
థ్యాంక్ యూ
Kalesha.
రాను.
One more
గుల్లకంటి
time.
కాళేశ. గుల్లకంటి కాళేశ.
Thank you. You're here in case
కృతజ్ఞ
25 CF 2069.
25 CF 069 ఈ కేసు గురించి మనం ఈరోజు కలిసాము. ఇక్కడ దాని గురించి మాట్లాడుతున్నాము.
You're charged with one count of traveling to meet a minor to engage in sexual contact, which is a second-degree felony.
ఇక్కడ మీరు మీ మీద మోపబడిన నేరం ఏంటంటే మీరు మైనర్ని, వయసులో చిన్నవాళ్ళని కలవడానికి శారీరక సంబంధం పెట్టుకునే ఉద్దేశంతో మీరు ఉన్న చోటు నుంచి వాళ్ళ దగ్గరికి కలవడానికి వెళ్ళడానికి ప్రయత్నించడము, అది సెకండ్ డిగ్రీ ఫెలనీ నేరం. అది
The maximum penalty for that charge is 15 years in prison.
దాదాపుగా మీకు 15 సంవత్సరాల వరకు చెరసాలలో మిమ్మల్ని పెట్టవచ్చు.
Count 2 is using a computer to facilitate or solicit a child.
రెండో కౌంట్ ఏంటంటే మీరు కంప్యూటర్ని ఉపయోగించుకొని చిన్నపిల్లల్ని మీ శారీరక వాంఛలు తీర్చుకోవడానికి వెతకడమో లేదంటే వాళ్ళ గురించి విచారణ చేయడమో, అది రెండో కౌంట్.
That's a third-degree felony with a maximum penalty of up to 5 years in prison.
అది థర్డ్ డిగ్రీ ఫెలన్ అవుతుంది. ఒకవేళ అది నిరూపించబడిందంటే 5 సంవత్సరాల వరకు మీకు చెరసాలలో వెంచే అవకాశం, అంత శిక్ష మీకు పడుతుంది.
And count 3 is unlawful use of a two-way communication device.
అది కౌంట్ మూడోది ఏంటంటే చట్టబద్ధంగా కాకుండా రెండు వైపుల నుంచి మాట్లాడే సాధనాన్ని ఉపయోగించడం.
That's also a third-degree felony with a maximum penalty of 5 years in prison.
అది కూడా థర్డ్ డిగ్రీ ఫెలనీ కిందకు వస్తుంది. అది దాదాపుగా 5 సంవత్సరాలు చెరసాలలో ఉంచేలా చేస్తున్నది.
Have you had a chance to talk to your lawyer about the charges and any possible defenses?
మీకు మీ వకీల్తో మాట్లాడే అవకాశం వచ్చిన ఈ విషయాల గురించి, మీ మీద మోపబడిన నేరాలు, దాని తర్వాత దానికి పర్యవసనాల గురించి మాట్లాడే అవకాశం మీకు దొరికిందా?
Yes.
All right, thank you. Have you?
Your Honor, I'm sorry, interpreter could not hear the response, but Judge, if Your Honor heard, that's fine.
Yeah, he said yes, but he does
Oh.
need to get close to that microphone.
మైక్రోఫోన్లో నుంచి మాట్లాడండి.
యా అవకాశం వచ్చింది.
Yes, I had an opportunity.
Wonderful, thank you.
కృతజ్ఞతలండి.
Have you discussed the plea agreement with your lawyer?
ఈ రోజు ఈ ప్లీ అగ్రిమెంట్ గురించి మీరు మాట్లాడుతున్నారు కదా, దాని గురించి మీరు మీ వకీల్తో మాట్లాడారా?
యా ఎస్
Yes, yes.
Sir, we do have an interpreter present. It's my understanding English is not your native language, correct?
అయ్యా, మీకు భాషా తర్జుమదారిని ఇక్కడ మీరు ఇచ్చారు, ప్రవేశపెట్టారు. మీకు ఇంగ్లీష్ మీ మొదటి భాష కాదని నాకు అర్థమవుతుంది.
యా అవును.
ఎస్.
Do you read English?
మీకు ఆంగ్లం చదవడం వచ్చా?
యా వచ్చు.
ఎస్, ఐ క్యాన్.
Did you read the plea agreement?
మీరు ఈ ప్లీ అగ్రిమెంట్ ని చదివారా?
చదివిన.
Yes, I have read.
Is that your signature on the last page?
యా నేనే సంతకం పెట్టిన.
Yes, I signed it.
Do you understand the rights that you give up when you enter a plea?
ప్లీకి ఒప్పుకొని దాంట్లో ఎంటర్ అయినప్పుడు దానికి సంబంధించిన హక్కులు మీరు వదిలేస్తున్నారన్న విషయం మీకు అర్థమవుతుందా?
అవును.
ఎస్.
Do you understand that you have the right to go to trial and you're giving up that right?
అలాగే మీకు ట్రయల్కి వెళ్ళడానికి హక్కు ఉన్న విషయం, హక్కు ఉన్నది ఒకటి, అది ఈ హక్కులు వదిలిపెట్టడంలో దాన్ని కూడా వదిలేస్తున్న విషయం మీకు అర్థమవుతుందా?
You can answer this.
ఎస్ అవును.
ఎస్, ఎస్.
Are you entering the plea freely and voluntarily?
మీరు ఈ ప్లీని నిర్భయంగా, నిరభ్యంతరంగా, ఎటువంటి ఇవి ఫోర్స్ లేకుండా స్వతంత్రంగా ఒప్పుకుంటున్నారా?
అవును.
ఎస్.
Is anyone forcing you or threatening you to make you enter a plea?
నో.
ఎవరైనా మిమ్మల్ని బెదిరించడం కానీ బలవంతంగానే చేస్తున్నారా ఈ నేరాలని ఒప్పుకోవడానికి?
లేదు లేదు.
నో, నో.
Has anyone promised you anything to make you enter a plea?
ఎవరైనా మీకేమన్నా ప్రమాణం చేశారా లేదా ప్రామిస్ చేశారా, నేను ఇది ఇస్తాను అది ఇస్తాను, మీరు ఈ నేరాలు ఒప్పుకుంటే?
లేదు లేదు. నో.
I think the interpreter is, oh, there we go.
Are you able to hear me?
Yes, now we are, yes.
నో.
Thank you. I was going to the closely to the monitor and then it is kicking me out, sorry.
No problem. Are you satisfied with the services of your lawyer?
మీ వకీలు మీకు ఇస్తున్న సర్వీసెస్ గురించి, అంటే ఆవిడ చేస్తున్న విషయాలలో మీకు సంతృప్తికరంగా ఉందా?
యా అవును.
ఎస్, ఎస్.
Did she answer all of your questions?
మీకున్న ప్రశ్నలన్నిటికీ, మీరు అడిగిన ప్రశ్నలన్నిటికీ ఆవిడ బదులు చెప్పారా?
అవును.
ఎస్.
Are you under the influence of any drugs or alcohol?
ప్రస్తుతానికి మీరు మందులో ఉండడం కానీ బోధ మందులు తీసుకోవడం కానీ దాని ప్రభావం మీ మీద ఉన్నారా?
నో.
నో.
I have a score sheet that shows 22 total sentence points.
I'm sorry, Your Honor.
I have a score sheet that shows 22 total sentence points.
No objection.
సో స్కోర్ షీట్ ఉంది, అందులో 22 సెనిక్ పాయింట్లు కనిపిస్తుంది, చూస్తున్నాను అని చెప్తున్నారు జడ్జి గారు.
No objection from the defense.
ప్రతి డిఫెన్స్ వకీల్ నుంచి ఎటువంటి అభ్యంతరాలు లేవంటున్నారు దానికి.
To the state, is there any exculpatory DNA?
There is not, ma'am.
స్టేట్ని అడిగారు, ఇంక ఇది కాకుండా వేరే ఎటువంటి డిఎన్ఏలు మీరు తీసుకున్నారా లేకపోతే ఉందా అంటే లేదు అని అంటున్నారు.
I do find a sufficient factual basis based on my review of the arrest report.
నేను అరెస్ట్ రిపోర్ట్స్ని రివ్యూ చేసిన తర్వాత కావలసిన నిజాలు అవన్నీ తెలుసుకోగలిగాను.
Sir, is there anything that I have said so far that you have not understood?
ఇంతవరకు నేను చెప్పిన విషయాలు ఏది మీకు అర్థం కాకుండా విషయం ఏమైనా ఉందా?
You can answer her, yes.
Yes.
There is something that I've said that you don't understand?
No.
మీకు అర్థం కానిది ఏది ఉందండి, ఏదైనా ఉందా అని అడుగుతున్నారు జడ్జి గారు.
లేదు.
నో నో.
Just to be clear, have you understood everything that I have said?
ఇంతవరకు జడ్జి గారు చెప్పిందంతా మీకు అర్థమైందా అండి?
యా, అర్థమైంది.
అండర్స్టూడ్.
Thank you.
అండర్స్టూడ్ యువర్ ఆనర్.
Thank you.
థ్యాంక్ యూ యువర్ ఆనర్.
Sir, if you are not a U.S. citizen, do you understand you could be deported?
అయ్యా మీకు అర్థమవుతుంది కదా, మీరు మీకు అమెరికన్ పౌరసత్వం లేదంటే మిమ్మల్ని తిరిగి మీ దేశానికి పంపించేస్తారు అని చెప్పేసి.
యా, అర్థమైంది.
yes understood.
It looks like you are only pleading to count 3, which is unlawful use of a two-way communication device.
సో మీరు ఇది ఎలా మాత్రమే మీ నేరం చెప్తున్నారు ఏంటంటే 2-way కమ్యూనికేషన్ వాడి మైండ్ని కాంటాక్ట్ చేయడం గురించి అని చెప్పేసి ఉంది. దానికి మాత్రమే మీరు ఒప్పుకుంటున్నారు నేరం.
Is that your understanding too?
అది మీకు అర్థమైందా అండి?
యా, అవును.
yes yes
All right.
yes.
In accordance with your agreement that you and your attorney have reached with the state, how do you plead to count 3?
సో మీకు మీ వకీల్కి మధ్య జరిగిన సంభాషణలో మీకు అర్థమైన దాంట్లో కౌంట్ 3కి సంబంధించి మీరు ఎలా నేరాన్ని ఒప్పుకుంటున్నారు అంటే ప్లీ ఎలా చేసుకుంటున్నారు?
No contents.
నో కాంటెస్ట్ యువర్ ఆనర్.
I accept your plea. I find it was freely and voluntarily entered.
సో నేను మీరు చెప్పిన మీరు అంగీకరించిన నేరాన్ని నేను ఒప్పుకుంటున్నాను. నాకు అర్థమవుతుంది మిమ్మల్ని ఎవరు బలవంతం చేయలేదు, ఏదైనా ఇస్తానని చెప్పి చెప్పకుండా మీ స్వతంత్రంగా నిరభ్యంతరంగా మీరు తీసుకున్న సొంతమైన నిర్ణయం అని చెప్పి నేను ఒప్పుకుంటున్నాను.
Does the state have an announcement on counts 1 and 2?
Yes, ma'am.
సో స్టేట్కి సంబంధించి కౌంట్ 1కి 2కి సంబంధించి ఏదైనా వాళ్ళు చెప్పాలనుకుంటున్నారా అంటున్నారు. మేడం కౌన్సిల్, మై అపాలజీస్.
Yes, ma'am. As to counts 1 and 2, the state would announce a null pros. Based upon the evidence, the state does not believe it can show the defendant's understanding and intent beyond a reasonable doubt.
Thank you.
Interpreter was unable to hear, Madam Counsel, Your Honor.
If you could get to that microphone,
Okay.
that would be
That's
great.
the problem is when we stand up, I think.
I know.
Thank you.
The whole thing again, ma'am?
Yes, please, I did not hear a thing, I know.
All right.
I know you, it's not daily practice to speak into the microphone.
Okay.
Trust me.
Ma'am, the state would announce a null pros as to counts 1 and 2. Based
No
up-
process. I'm so sorry, I still cannot hear you. I could hear 1 and 2 counts, but before that, I could not hear you.
The state announces a null pros as to counts 1 and 2.
Okay, state state ledu count 1 and 2 ki.
Based upon the evidence, the state does
Yes.
not believe it can prove.
ఆధారాలను పట్టుకొని స్టేట్ దీన్ని నిరూపించగలదు అని వాళ్ళు అనుకుంటున్నారు. ఇదే 1-2 నిరూపించలేమో అని వాళ్ళకి తెలుస్తుంది.
The defendant's understanding and intent beyond a reasonable doubt.
సో తనకి అంటే ఇప్పుడు వాళ్ళు నిరూపించలేరు, మీకు అర్థమైంది ఎటువంటి సందేహానికి తావు లేకుండా వాళ్ళు ఇది నిరూపించలేరు అనే విషయాన్ని వాళ్ళకి అర్థమవుతుంది అని చెప్తున్నారు.
Thank you.
థ్యాంక్ యూ మేడం కౌన్సిల్. థ్యాంక్ యూ యువర్ ఆనర్.
Oh, yes, thank you. So, sir, in accordance with your agreement, on count
Me-
3, there is an adjudication of guilt.
అడ్జుడికేషన్ అపీల్. ఓకే, సో కౌంట్ 3లే మీకు మీ ఒప్పుకున్న దాని ప్రకారం కౌంట్ 3లో మీకు అడ్జుడికేషన్ అపీల్ ఒకటి ఉంటుంది అని చెప్తున్నారు.
You are placed on probation for 60 months.
60 నెలలు ప్రొబేషన్లో మిమ్మల్ని ఉంచబడుతుంది.
You will pay a cost of supervision of $40 per month.
సో ఈ మిమ్మల్ని సూపర్వైజ్ చేయడానికి సంబంధించిన కాస్ట్ అంటే ఖర్చులు $40 ప్రతి నెల మీరు పే చేయాల్సి ఉంటుంది.
There will also be a small surcharge on that cost of supervision.
అలాగే దానికి అదనంగా సర్చార్జ్ అనేది కూడా ఉంటుంది ఆ సూపర్విజన్ పైన.
Ms. Merrifield, Madam Clerk, is telling me the costs are $515.
Thank you, ma'am.
Do you know where the extra $3 is coming?
No, ma'am, but we certainly have no objection to that.
Okay. Well, if it
సో
turns out to be
సో
$518.
సో $518 అవుతుంది. మాకు ఈ దీనికి సంబంధించి ఎటువంటి అభ్యంతరాలు లేవని చెప్పేసి మీ వకీల్ చెప్తున్నారు.
Whatever the mandatory required court costs are, the court is imposing those.
సో అలాగే కోర్టుకు సంబంధించిన ఎటువంటి ఖర్చులు ఉన్నాయో అవి కూడా దీనికి జత చేస్తున్నారని చెప్తున్నారు.
I will defer to the clerk to figure out what that is.
క్లర్క్ మేడం క్లర్క్కి అవకాశం ఇచ్చి ఎంత ఉంటుంది అని చెప్పేసి అది తెలియచేయమని చెప్పి దాని నిర్ధారణకు రమ్మని చెప్తున్నాము.
And Madam Clerk is telling me it's $515.
సో మేడం క్లర్క్ చెప్పారు $515.
All of the standard terms and conditions of probation will apply.
సో సాధారణంగా ప్రొబేషన్లో ఉంటున్న కండిషన్స్ అన్నీ మీకు అది మీకు ఒప్పుదల అంటే మీకు అప్లై అవుతుంది అనమాట.
Your probation officer will go over those with you.
అలాగే మీ ప్రొబేషన్ ఆఫీసర్ దానికి సంబంధించిన వివరాలన్నీ మీకు వివరంగా చెప్తారు.
The special conditions are no
ప్రత్యేకమైన కండిషన్స్ ఏంటి?
no unsupervised contact with any minors.
చిన్న పిల్లలతో సూపర్వైజన్ లేకుండా వాళ్ళతో సంప్రదింపులు చేయకూడదు.
And you may not be in a place where minors congregate.
అలాగే మీరు చిన్న పిల్లలు ఎక్కడ కలిసే జగ ఉంటుందో అక్కడ మీరు వెళ్ళకూడదు, అక్కడ ఆ స్థలాల్లో మీరు ఉండకూడదు.
Such as parks, playgrounds, schools, daycares.
పార్క్స్ కానీ స్కూల్స్ కానివ్వండి, ఆట ఆడుకునే స్థలాలు కానివ్వండి, అలాగే డే కేర్స్ ఇక్కడెక్కడ ఉండకూడదు మీరు.
Those are some examples.
ఉదాహరణకి ఇవి కొన్ని ఉదాహరణలు అన్నమాట మీరు ఎక్కడెక్కడ ఉండకూడదు అనే విషయాలకి.
To the attorneys, did I cover everything?
వకీల్ గారిని అడుగుతున్నారు ఏదైనా నేను అన్ని కవర్ చేశాను అంటున్నారు.
Okay. Sir, you will have 30 days to appeal the order of the court.
నిర్ణయాన్ని మీరు పైన కోర్టులో అపీల్ చేసుకోవాలంటే మీకు 30 రోజుల టైం ఉందండి.
If you cannot afford a lawyer, I will appoint one for you.
అలాగే మీకు ఒక వకీల్ని పెట్టుకునే స్తోమత లేదు అంటే నేను ఒక వకీల్ని మీకు అపాయింట్ చేస్తాను.
I see Officer Doobie is standing and probably wants to say something.
Your Honor, just two questions.
అక్కడ ఆఫీసర్ టీవీఎస్ అక్కడ వెనకాల నిల్చున్నారు, ఆయన ఏమైనా చెప్తానని అనుకుంటున్నాను.
One would be the arrest report shows an address of Plymouth, Minnesota. I'm just wondering if there's a local address or if it's going to be a possible out-of-state transfer, which would involve the $125 fee. And then the second would be just with have a Madam Interpreter here to be able to tell him the address of the probation office.
Okay.
Interpreter was unable to hear a thing, Your Honor. My sincere apologies.
No problem.
Judge, I can maybe run a little bit of interference. I just want to be clear. So Mr. Kalisha does understand a pretty good degree of English. I have had no issues communicating with him as long as it is very slow. But for purposes of a legal disposition and understanding context, I felt that it was important to have a translator here for more complex issues. But I can provide the address to probation. He does reside out of state. There may be a transfer issue, but there is also an ICE issue that we need to address first.
Okay.
సో మీ వకీల్ గారు ఏమంటారు, ఆ ఆఫీసర్ గారు చెప్పిన విషయాలు నేను ఇంటర్ప్రిటర్ వినలేకపోయారు. సో నేను జడ్జి గారికి ఇదే చెప్తే మీ వకీల్ గారు అన్నారు, నేను మాట్లాడతాను క్లుప్తంగా. మిస్టర్ కనేష, మీకు ఆంగ్లం ఒక రకంగా అర్థమవుతుంది, నిదానంగా మాట్లాడితే. ఇంతవరకు నేను ఆయనతో మాట్లాడడానికి నాకు ఎటువంటి ఇబ్బందులు ఎదురు కాలేదు. ఆయన వేరే స్టేట్లో ఉంటారు. చెప్పిన విషయాలని ఆయనకు అర్థమైంది. అలాగే ఇప్పుడు ఆయనకి వేరే స్టేట్కి వెళ్ళడానికి దాని ట్రాన్స్ఫర్ విషయాలు మనం మాట్లాడుకోవాలి. అలాగే చెప్పారు. ఎందుకు నేను ఇంటర్ప్రెటర్ని తీసుకున్నాను అంటే, చట్టానికి సంబంధించిన కొన్ని సమస్యలు, కొన్ని మాటలు సరిగా అర్థం కావు కాబట్టి దానికి వివరంగా తెలుసుకోవడానికి మాత్రమే నేను తీసుకున్నాను. ఆయన ఇంగ్లీష్లో నేను మాట్లాడిన విషయాలని ఆయనకి నేను నెమ్మదిగా మాట్లాడితే అర్థమవుతుందని చెప్పారు. థ్యాంక్ యూ, యువర్ ఆనర్. థ్యాంక్ యూ, మేడం కౌన్సిల్.
Thank you. So, sir, you will need to see Officer Doobie. He's a probation officer. He is sitting right over there before you leave the courtroom.
అయ్యా, మీరు ఈరోజు కోర్ట్ రూమ్ నుంచి వెళ్ళిపోవడానికి ముందు అక్కడ ప్రొబేషన్ ఆఫీసర్ డూబీ ఉన్నారు, ఆయన వెనకల ఉన్నారు. ఆయనతో మీరు కలిసి ఆయనతో మాట్లాడాలి మీరు.
Judge, I would like to address one more thing before we close out.
Okay, and sir, if you end up transferring your probation out of state, there is an additional fee, and Officer Doobie can talk to you about that.
అలాగే మీరు అడిషనల్గా ఇంకొక విషయం ఏం చెప్పాలనుకుంటున్నారంటే, మీరు ఈ స్టేట్ నుంచి వేరే స్టేట్కి మీరు ట్రాన్స్ఫర్ తీసుకున్నారంటే దానికి సంబంధించి కొంత ఫీ ఉంటుంది. ఆఫీసర్ డూబీ గారు మీతో దాని గురించి మాట్లాడతారు.
You must report to probation as soon as you get out of custody.
సో మీరు కస్టడీలో నుంచి బయటికి రాగానే మీరు వెంటనే ప్రొబేషన్ ఆఫీసర్ని కలవాలి.
All right.
Thank you. Judge, there was certain property that was seized from Mr. Gulakante during his arrest, his cell phone and his vehicle. I've spoken with ASA Bassau. I don't believe she has any objection. So I do have a stipulated order to release that property. If the court prefers, I can send it through the portal or I can provide a hard copy today.
Let's let the.
సో వకీల్ గారు ఏం చెప్పారంటే, ఈయనని అరెస్ట్ చేసినప్పుడు ఈయనకి సొంతమైన వస్తువులు కొన్ని వాళ్ళ ఆధీనంలో ఉన్నాయి. అది ఒక సెల్ ఫోను, ఒక కారు. అది ఈ రోజు ఇవ్వడానికి మేము అడుగుతున్నాము. వాళ్ళకి ఎటువంటి అభ్యంతరం లేదు ఇవ్వడానికి. మీకు కావాలి అంటే నేను పోర్టల్లో నుంచి సాఫ్ట్ కాపీ అప్లోడ్ చేస్తాను, లేదంటే ఇప్పుడే మీకు హార్డ్ కాపీ చేతిలో ఇస్తాను అని చెప్తున్నారు.
Okay.
Does the state have any objection?
Yes, Your Honor.
No objection, ma'am.
సో స్టేట్ వకీల్ని అడిగారు, మీకేమైనా అభ్యంతరాలు ఉన్నాయంటే మాకు ఎటువంటి అభ్యంతరాలు లేవని వాళ్ళు చెప్పారు.
May I approach?
Yes.
సో నేను ఇవ్వచ్చా మీకు అన్నారు. మీ వకీల్ గారు వెళ్ళి ఆయనకి అక్కడ ఇచ్చారు.
I'm signing the order to release the defendant's property to him. The state does not object.
సో స్టేట్ నుంచి ఎటువంటి అభ్యంతరం లేకపోవడాన్ని నేను దీని మీద సంతకం చేసి మీ వస్తువులు మీకు రిలీజ్ చేయమని ఆ ఉత్తర్వు మీద నేను సంతకం పెడుతున్నాను అని జడ్జి గారు చెప్పారు.
Thank you, Judge. We'll check in with probation now.
Thank you
మేము
so much.
ప్రొబేషన్ తో చెకింగ్ చేసుకుంటున్నాం. థ్యాంక్ యూ, యువర్ ఆనర్. Am I all done, Your Honor?
Thank you very much, Madam Interpreter, very much for your help today. Thank you.
Thank you, Your Honor. You have a good day. Thank you.
Thank you.
Judge, I'll call my next case in a minute. I just need to.
Yes. All
Bye-bye,
right.
ma'am. Have a good day.
Thank you, you too.
Sure.
Let's see, do I have Mr. Lupella present? I don't see Mr. Lupella. He's running between courtrooms. All right, Mr. Ballack. And I believe this is going to be number 1 on the transport list.
Mr. Honors, Tyran Claiborne, I believe he's getting brought out, 25 CF 2469. We had a motion to dismiss on the court's docket.
Okay, so this is Mr. Claiborne, 25 CF 2469. That's the motion to dismiss case. And then he also has a violation of probation case, 24 CF 526, which is just on the docket to track along. And I'm aware that he also has another case with Mr. Koch, 26 CF 913. But we're only here today on the motion in 25 CF 2469. So let me,
Well, and before we begin, Your Honor, I think the motion might be moot because I believe that the state has an announcement to make.
oh, okay, so let me just get to that. All right, so we're here on defendant's motion to dismiss. I have Ms. Gaynor present for the state. Defendant is present.
Yes, Your Honor, I believe the motion to dismiss is regarding counts 1 and 2. The state will be null crossing counts 1 and 2, leaving 3 and 4 remaining, but that would essentially make the motion to dismiss moot at this point.
Thank you. All right, state has dropped counts 1 and 2, so we've still got, in this particular case, count 3 and count 4 remaining. That does dispose of the motion to dismiss, and all 3 cases are currently set for August 12th, but I believe we may need to move, no, that is the right day. That's the in custody day. Okay, sir, we'll see you on August 12th on all 3 of your cases.
Thank you, ma'am.
Thank you. Thank you, Mr. Ballard.
Thank you, Your Honor. That's all I have for today, Steve.
Yes.
Have a good day.
I'm not sure who was here first, Mr. Harper or Mr. Nopes.
Mine won't be very long.
Come on. Mr. Nopes, you're here on Ms. Henson, Pamela Henson,
Yes, sir. Yes, ma'am.
and she's number 3 on the list. All right, and this is case number 23 CF 818 and 25 CF 2466, and she will be out momentarily. All right, Ms. Henson is present, and we're here on status of competency restoration. And I did review the report that was recently filed.
It was filed yesterday afternoon, Your Honor.
Yes. All right, does the state wish to be heard, or Mr. Nopes, how do you wish to proceed?
Judge, basically, this report suggests to me that she's doing a lot better, and I think the recommendation of of Margaret Varela, the forensic mental health specialist, is they're trying to get her over into one hopeful place.
No, I have an address.
Okay, well, I understand.
All right, we're going to have to proceed, so do you
Judge-
need me to pass the cases?
Judge, it's a little bit of a surprise. This is suggesting one hopeful place. She's telling me that she has an address now that she could move to.
Yes, she filed it in court. She filed it yesterday. She said she emailed it to the court that I was going to an address, a different address, one where I have rented. I have an income.
Okay, well,
We
Be that
haven't
as it
gotten
may.
that yet. Judge, I'll contact Miss
Please, let's get this under.
Miss Varela Because that's inconsistent with what was at 1 o'clock yesterday afternoon.
Oh, yes, she's here.
Okay, I'm sorry.
Okay.
Thank you, Lord.
All right, Ms. Varela is present.
Yes, Your Honor.
Oh.
So Ms. Henson's progress is that she is meeting with me at the jail. We are making some progress. Progress is a little slow due to access, jail requirements, and other detainees that I'm having to meet. If the court would to consider conditional release, Ms. Henson has indicated that she would participate and meet with me and continue her medication. If the court will not consider that, we can continue conditional release, jail-based. Whatever
Thank
the court
you.
suggests, either setting.
Thank you.
Ms. Varela,
Yes, sir.
are you aware of another address versus the Okaloosa place?
Yes, she has a friend, Miss Julie Sanders.
Sanders, yeah.
That is her good friend that has offered to allow her to reside at her place until she's able to get her finances together.
I have an income.
So,
Thank you.
but when were you made aware of that?
Miss Sanders notified me of that yesterday.
Okay. So is that your recommendation, that she would be released and stay with Ms. Sanders?
Yes.
Okay.
That's what I will be.
Thank you. Thank you.
That's
All
all
right.
I've got, Your Honor.
What's the state's position?
So I guess I see that in the report, right, where I believe there's, in the housing verification status, there's a mention of One Hopeful Place. And then the next sentence says that Ms. Henson's power of attorney, Ms. Sanders, has confirmed that she can reside with her. So I guess,
The actual address just wasn't provided to me yesterday. Miss Sanders just communicated to me that she could reside with her.
Okay, thank you. So I understand about Ms. Sanders and, I read the report. The fact of the matter is, Ms. Henson is before the court on 2 open cases. And while she was on conditional release on the first case, she picked up the second case, plus at least 1 misdemeanor, if I'm not mistaken. The court's not willing to consider
Ma'am.
release, not right now. I'm making a ruling. The court is not willing to consider release, so we're going to continue with jail-based restoration for that reason.
May
The
I
court's
say
not going to
something?
reinstate release.
Ma'am, may I say something?
You can talk to your lawyer, ma'am.
No, well, can I say something to you to maybe,
It's not going to change the court's ruling.
I was on pretrial for 3 full years, pretrial release without violating.
Ma'am, the court has ruled, but thank you. Let's get you a new court date. When do you want to set the next court date? I think we're probably set for, well,
3 full years on pretrial, ma'am. Checking in once a week and never had an issue.
but then there were multiple. So
But I'm
that's the
not even
reason for the
proven
court's
guilty of these
ruling. I'm not
charges.
gonna argue with you. I've ruled. That's the court's ruling. So let's look for, do you want August or September,
Because I think
Mr.
it's on,
Noakes?
I think it might be currently set for July 21st, but I'm
That's
not certain.
Today
Today.
is July
Oh,
21st.
that explains it.
Okay, how about August 18th? Or we could have September 22nd, either one.
This is, I was on pretrial for 3 years while Rudy did nothing.
So August 18th then.
That's fine, Judge. Is that
All
what-
right, 9 o'clock,
Okay.
and that'll be for
This one.
No,
competency status. All right, thank you.
Hey, will you put it back there when I speak to you?
I have one ready, Judge.
Thank you.
This one should be a little bit easier.
So sorry?
Should be a little bit easier on this one, Judge.
Okay.
Brady Merrifield on behalf of Tyler Otten, it's 25 CF 1004. Mr. Otten is present, and we have reached an agreement, Judge, if I may approach.
Yes, thank you. Thank you. Oh. If you wish, I'm going to announce it anyway, so
I'll just
either
give
way.
just a brief, Mr. Otten is withdrawing his previously entered not guilty plea, is entering a no contest plea. As the court can see, there are various charges, and it is going to be to a probation plea, just so the court is aware. This does involve sex offender probation. I have discussed with probation, both in Okaloosa and Bay County, where he will reside, to verify address and work through those complications prior to setting this for today. And it is going to be an adjudication.
All right. Is there a designation?
Yes, ma'am,
Okay.
and he has been so advised.
Oh, I do see that in here. Thank you.
Yes, ma'am.
All right.
And the terms do address statutory requirements, Judge.
Sorry?
The terms do address
Oh.
the statutory requirements.
Thank you.
Yes, ma'am.
Will you raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you. You can put your hand down. And if you'll just tell me your name, please.
Tyler Chase Houghton.
Thank you, Mr. Otten. You're here in case 25 CF 1004, and you are charged with 5 counts of using a computer to facilitate or solicit the sexual conduct of a child. Each of those is a third-degree felony with a maximum penalty of 5 years in prison. Then counts 6 through 24 are transmission of harmful materials to a minor. Each of those is a third-degree felony with a maximum penalty of up to 5 years in prison. And then count 25 is unlawful use of a two-way communication device, which is also a third-degree felony with a maximum penalty of up to 5 years in prison. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes, ma'am.
All right, have you discussed the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, Your Honor.
Do you understand you have the right to go to trial and make the state prove that you're guilty beyond a reasonable doubt?
Yes, ma'am.
Do you understand you're giving up that right?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
I have a score sheet. It shows 128.2 total sentence points for a lowest permissible prison sentence of 75.15 months.
No objection to the score sheet from the defense.
Thank you. To the state, this is a downward departure, correct?
Yes, ma'am. The state had the benefit of a mental health and intellectual functioning assessment. Based on that, we do believe there's an appropriate basis for a downward departure, and we do believe we have the appropriate safeguards in place for the community with the sentence that we're imposing.
Defense
Okay.
would agree with that.
So it's a legitimate uncoerced plea bargain?
Yes, ma'am.
Okay. Is there any exculpatory DNA?
There is not.
Okay. I do find a sufficient factual basis based on my review of the arrest report. Sir, do you understand that if you are not a U.S. citizen, you could be deported?
Yes, ma'am.
Do you understand that you're going to be a designated sex offender as a result of this plea?
Yes, ma'am.
And the court costs on here show 661. Thank you. All right, according to your agreement, it looks like you will be entering a plea only to counts 1 through 6. Excuse me, 1 second. 6 is transmission. All right, so I was just verifying the cost. So, looks like you're entering a plea to only counts 1 through 6. Is that your understanding?
Yes, ma'am.
How do you plead to counts 1 through 6?
No contest.
I accept your plea. I find it was freely and voluntarily entered. Does the state have an announcement on counts 7 through 25?
Yes, the state would announce the null process on counts 7 through 25 based on the plea to 1 through 6.
All right. As to counts 1 through 6, there is an adjudication of guilt. In accordance with your plea agreement, on count 1, you will be placed on sex offender probation for a period of 60 months. You must have a sex offender evaluation and counseling. You may not have any unsupervised contact with any minors. You may not be in a place where minors congregate, such as, I'm giving you examples, parks, playgrounds, arcades, daycares. Those are just some examples, but anywhere minors congregate, you cannot be. You may not have any electronic devices capable of accessing the internet. You may petition the court for internet use after you have completed a risk assessment as allowed by statute. So just because you've completed the risk assessment does not automatically mean you can access the internet. You will be designated as a sex offender in accordance with Florida Statute 943.0435. That will include all statutory requirements. Is there a GPS requirement for sex
There is
offender?
not by statute based on,
I'm sorry.
based on these offenses, not by statute, no.
However, ma'am, if there is a violation, then it would be required if DNC is not imposed.
Thank you.
And that has been discussed in detail with Mr. Otten and his family.
Thank you. There will be a curfew while you're on probation of 10 p.m. to 6 a.m. That can be adjusted by probation to accommodate your work schedule if your work schedule is out of those hours. You will pay a monthly cost of supervision. It's $40 per month. There's a surcharge that goes along with that of a few dollars. So that's as to count 1. Count 2 is 60 months of sex offender probation consecutive to count 1. And it looks like all of the same terms and conditions that I just announced on count 1 will apply, including the cost of supervision. And the court is imposing $515 in court costs. That is what Madam Clerk is telling me that the mandatory court costs are for the charges that, Mr. Otten, that you pled to. If the mandatory court costs turn out to be different, the court is imposing whatever the mandatory costs are.
Thank you, Judge.
Sure. As to counts 3 through 6, on each count, you're placed on 60 months of sex offender probation concurrent with counts 1 and 2 and with each other. And you will serve a total of 120 months. That's 10 years. Sex offender probation. That's count 1 followed by count 2. And you reside in Bay County. The court has no objection to you transferring your probation over to Bay County. I see Officer Doobie is wanting to be heard.
Your Honor, just a clarification on counts 3 through 6. We have a consecutive on counts 1 and 2, so we want concurrent on
With count 1.
correct?
With count 1.
Thank you.
Yes, is that, well, is
That is the understanding.
That's the understanding, ma'am.
Okay, so it would be 3 through 6 are concurrent with count 1. I'll cross off count 2 on here.
Just concurrent with each other, so they run together like we talked about.
So counts 3 through 6 are running at the same time as count 1, and all of that would be, I mean, you'd still once you complete the probation on count 1, then count 2 begins. So it's consecutive, back to back on counts 1 and 2. Did I cover everything?
Yes, ma'am.
Yes, ma'am.
Okay. So, sir, you'll have 30 days to appeal the order of the court. If you cannot afford a lawyer,
No, not yet.
I will appoint one for you. Good luck to you. See Officer Doobie, he's sitting right over there before you leave the courtroom, and you need to go to probation. When you leave the courthouse, go straight to probation and check in today.
Yes,
And I
ma'am.
think you have to have fingerprints.
That's all I have today, ma'am. Thank you.
Thank you.
Thank you. Ms. Merrifield?
Yes, ma'am.
And the defendant will be adjudicated or designated as a sex offender.
Thank you.
And Ms. Basso, will you send that order designating
Yes,
Mr.
ma'am, I
Otten?
will.
Okay, thank you. All right, Mr. Lupella. Good morning. And it looks like you're here on Mr. Harchar, 25 CF 2274 and 25 CF 2274 and 2275. We're here on status of transport to Florida State Hospital. And I think he was transported to court today, so he'll be out shortly. And he is present, and I did review the report from Ms. Valera, the forensic mental health specialist, that says he's not a candidate for diversion, and he's on the wait list for transport. So anything that either attorney needs to be heard on?
No, Your Honor. We're just
Let's
waiting.
set another court date. Do you want 1 month or 2 months out? Simply just check on status, 2 months? How about September 22nd at 9 o'clock? And if Mr. Harchar has already been transported, Mr. Lupella, could you please file a notice of cancellation? We would only need to come to court if he's still in jail.
September 22nd.
Yes, at 9 o'clock. But if he's already gone to Florida State Hospital, we don't need to have that hearing, so please file a notice of cancellation. Thank you.
Thank you. Good day, Your Honor.
Thank you, Mr. Lupella, very much. All right. Mr. Harper?
Yes, Judge, this should be relatively quick. I have David Bishop, number 8 on the docket, 24 MM.
24 CF 277, he refused transport, I've been told.
Yes, Judge, sorry.
That's-
With respect to the refusal, Judge, when I spoke with him, he meant no disrespect. He has a myriad of health problems, least of which is a fused back, and being shackled and sitting on the concrete is problematic. It causes him days of pain.
I
And
understand.
it was my understanding that we're unlikely to achieve a resolution today. What I'd like to do is, if I could have one last continuance, it will come to a conclusion next cycle or next miscellaneous court dates. I have the state's offer and the score sheet, and I think we'll probably resolve it on that date, Judge.
That's without objection, ma'am. We had discussed that, Mr. Harper and I.
All right, that's August 18th at 9 o'clock. So this will be the last one. So if he doesn't resolve it, then we need to schedule an evidentiary.
Yes, Judge, and I'll have him transported
Okay.
on the 18th, and he will be present.
Wonderful.
Thank you, Judge.
Thank you.
Thank you, Mr. Harper.
All right, let me bring in, we have some people on Zoom, so I'm going to bring them in. Yes. All right, good morning. And let's see, I have On Zoom, I have Mr. Cobb, and I also have Ms. Porto, APD attorney. And Ms. Porto, are you here on Javion Sharp?
Yes, ma'am.
Okay, I believe, well, let me see if that's, I think that's Mr. Koch's case, or is that Mr. Medina?
Judge, that is my case.
Okay, let me see if we can bring out Mr. Sharp, or if he's lined up, or do we need to? Okay, thank you. All right, so this will be Javion Sharp, 24 CF 1562, 24 CF 1563, 24 CF 1564, and 24 CF 1685. I have Mr. Koch present. I have Ms. Porto present from APD. And the defendant will be out momentarily. And who do I have for the state?
Jessica Jardine, Your Honor.
Wonderful, thank you. All right, and the defendant is present. So we're here on a status. I appointed an examining committee, and I also appointed APD. As to the examining committee, I have since learned, well, the attorneys can correct me on this one, but I believe one of the experts I appointed does not do these types of evaluations. Is that what you?
That is correct, Your Honor. It's Dr. Stevens.
Yes, so I have reached out to court administration for guidance on another expert, because there were only three, I guess, on the list. I appointed the only three that I could find on the list for these types of evaluations, but apparently Dr. Salinas does not do them. I've asked for help with finding a replacement expert. I received word back with the name of another expert, but that one does remote only. I do not know whether the jail can do, I didn't think they could do a Zoom evaluation, but if they can.
I believe they can, Your Honor. I'm sorry, because I believe that Dr. Henderson actually did hers by Zoom. So I believe that they can.
Wonderful. And Dr. Henderson, is that the APD expert?
Yes, Your Honor.
Oh, great. Okay. What is Dr. Henderson's first name?
It's Angela. Yes, Angela L. Henderson.
Okay, the reason I ask is the name of the expert that I received from court administration. I cannot remember it right now, but when you said Henderson, it sounded a little bit familiar, and I wanted to make sure that it's not the same one. Okay, so she has done her evaluation.
And yes, and I want to apologize. We received it, the region received it yesterday. Unfortunately, I was out sick with a migraine yesterday, so I have it and it will be filed, but I've just seen it today, so I just got it.
That's fine, because the reports from the other two, well, the examining committee that I appointed, we haven't gotten any reports back from anyone that I know of yet.
Your Honor, Dr. McDonald sent over an evaluation. I can check if it's filed
Okay.
or filed. We received it yesterday afternoon, so
Okay,
if it is filed, it might just not have come through yet.
okay. Well, that's good that that's been completed. All right. So I'll appoint another expert. We're still waiting on Dr. Pritchard's report. And what I probably need to do is set another status and see where we are with getting all of the reports. Unless, does anyone wish to be heard or bring anything to the court's attention?
Nothing from the fence, Your Honor.
Your Honor,
Yes,
I'm sorry.
go ahead.
Your Honor, there may be a couple issues. I'm still researching them, just by virtue of the fact that unless I am missing an amended order, I believe the only order of adjudicating the defendant incompetent to proceed is due to mental illness. and not due to an intellectual disability. So I am researching the issue. I do believe that could create some sort of issue in then going into the APD sphere. However, I can't say for certain because I have not found the specific legal authority that says that. I was informed that it might exist, so I am looking for it.
Thank you, and if I need to enter a different type of order, I will do so because the court
Yes,
does
Your Honor.
find, yes.
I just want to make sure that, that there are no issues, essentially just connecting all of the legal dots, I guess.
Absolutely, so if I need to do another order, or different type of order, or amended order, or any type of order, finding that Mr. Sharp is incompetent due to intellectual disability, the court so finds. So,
yes, Your Honor.
yes. Anything else from anybody that I need to address or cover today?
Nothing from the state, Your Honor.
Nothing from defense, Judge.
All right, so then why don't we schedule August 18th for a status on all of the remaining reports? And that'll be at 9 o'clock Central Time. And Ms. Porto, it'll be the same Zoom link.
Thank you very much. Excuse me, do I need to either file a notice or a motion to appear remotely or notify your judicial assistant or anything of that nature to make sure that everyone's on notice?
If you would, since you're with APD, if you would please notify my judicial assistant, motion's not required for you since you're with APD. If you'll just notify my JA so that I can make sure I turn on Zoom for you, she'll remind me.
Yes, ma'am. I will make sure that we send her
Yes.
that information prior to the hearing.
Yes, and that'll be absolutely fine. Thank you very much. So August 18th, 9 o'clock Central Time, and also Ms. Porto, as you probably know from today, and also I know you've been in my courtroom on other cases, even though it's set at 9 o'clock, you may not get called at 9 o'clock, but I'll call you as soon as I can.
Yes, ma'am. I understand court time is very different from other time. I've
It is.
been doing this quite some time, so
Thank you. All right.
thank you very much.
All right, so that'll conclude.
When will I be
Thank you.
going home?
I'm not sure. We're working on some doctors to come see you, okay?
Okay, I'm not incompetent and I understand what's going on.
Okay. Thank you. All right.
Judge Clark?
Yes.
Ma'am, may I inquire about a case since we're on competency issues? Mr.
So-
Kevin Escobar Munoz was supposed to be on today's docket. There was some question as to whether or not it was going to be rescheduled. It appears that he was not transported.
Yes, because, well, let me call that case real quick.
Yes, ma'am. That's going to be case number 241664 with Mr. Thomas Koch.
Yes, 24 CF 1664, Mr. Kevin Escobar Munoz. That, he was not transported because the hearing has to be reset, because there is a DCF attorney who has filed a motion to intervene, and she was not able to attend the hearing today. So we're trying to coordinate a new hearing date
I
on
did
that.
notice that Ms. Bailey had reached out to us and was inquiring as to Thursday, indicated that the state could be available, and I believe Mr. Koch may be, but I don't know that we had heard back from the attorney yet.
Okay, so I removed Mr. Escobar Munoz from the transport list because we were gonna have to reset the hearing anyway, and I just didn't have a chance to get it taken off the docket, so I figured we'd come into court and say this hearing is being rescheduled so that the DCF attorney, Ms. Battaglia Mercar, can be present.
Thank you, ma'am. I didn't want to just assume.
No problem. So my JA will continue to make efforts to find a good date.
Thank you.
Okay. All right. What, you know what I probably need to do, though?
For control purposes, put them
Let me put a control date on it, just in case, so that way it doesn't fall through the cracks. I will put August 18th or?
Sounds good, ma'am. We should
Okay.
have something hopefully before then, as far as that hearing goes.
Okay, so that might change. I'll just so that the case doesn't fall through the cracks, I'm going to put August 18th, 9 o'clock for Mr. Escobar Munoz, with the intention that we find a specific date when all the attorneys can be present, which hopefully would be before then, but, all right, thank you. Mr. Cobb?
Yes, ma'am. Good morning, Your Honor.
Good morning.
Or-
So, let's see, you're here on Matthew Goff, 25
Yes,
CF
ma'am.
2143, and he is approaching, and who do I have for the state on this one? Wonderful, thank you. Mr. Goff is present. We're here on the motion to dismiss filed by Mr. Cobb on behalf of Mr. Goff. And the state filed a demur. And it's, the whole motion turns on the definition of electronic record, it looks like.
Yes, ma'am. And I'm sure the court's had opportunity to review and consider my motion and the state's motion, so I would just like to have a moment to make a real brief argument.
Go
And then
ahead.
I leave to discretion of the court. Yes, ma'am. Thank you for letting me appear by Zoom, by the way. Greatly appreciated.
Sure, go ahead.
Yeah, the statute at issue was amended in 2021 to specifically exclude a telephone call from the definition of what is and what is not an electronic record. And so if we look at the statute in subparagraph 1, it states, any record modified, archived, received, or distributed electronically, which contains any combination of 1, a text, 2, graphics, 3, a video, 4, audio, and 5, pictorial representations, represented in digital form, but does not include a telephone call. So at the very get-go, when you're considering what can be included as a combination to make an electronic record, a telephone call has to be excluded. So it's very clear to me, Your Honor, that the legislature specifically excluded a telephone call as being a medium that can be combined together with other mediums to make an electronic record. And this makes sense because when you read the legislative record and the history surrounding the amendment of the statute, they were very concerned with TikTok, Instagram, Reels, things like that, that type of medium, when they decided to revamp the statute and remove electronic communications and replace it with what the term is electronic record. So the state's going to argue that the telephone portion of the voice message is audio, and that audio combined with a combination of it being recorded on a machine constitutes an electronic record. But the statute clearly says a telephone call cannot be included as an audio portion of what can be combined to create an electronic record. So in this case, there's no getting around the fact that the defendant's telephone call is part of the combination that the state is using to argue that what we have here is an electronic record for purposes of this statute. And I'm saying it's absolutely not. And I think the statute is very clear. A telephone call cannot be included in any combination with any other form of medium to establish and or make an electronic record. So then if you move to subparagraph 2 of the statute, it says it is unlawful for any person to send, post, or transmit or procure the sending, posting, or transmission of a writing or other record, including an electronic record, in any manner in which it may be viewed. And I'm emphasizing the word viewed by another person. There's absolutely no part of the facts of this case that state or indicate that this probation officer actually viewed anything. She listened. And I'm saying the legislature specifically included this language about viewing because their main concern were TikTok videos, Reels, Facebook, Instagram, stuff like that, viewing something. It never was intended to be something that you listen to as part of a telephone call. So I don't think the facts of this case constitute a crime. I don't think by any stretch of the imagination you can even come close to having a prima facie case. I don't think this is a situation where we have to let a jury do statutory interpretation and construction. God forbid we ever give them that power, especially as a defense attorney. So we sit here today, Your Honor, you're the gatekeeper when it comes to these type of issues. This is not a matter for the jury to decide, like the state argued in its response. This is a matter for the court to decide, and based upon the clear language in the statute, there is no crime here based upon these facts, and therefore we're asking you to dismiss the case. And if the state feels a need to find a more applicable statute that fits what happened here, that's their prerogative, they can do that. But they can't take this statute, stretch it, twist it, to try to suit themselves, because it just doesn't add up, because a telephone call cannot be included as any type of combination that consists or makes an electronic record.
Thank you. And Ms. Giardina?
Your Honor, the state's argument is laid out in the demurrer that was filed. The state relies on the plain language of the statute. The legislature explicitly lists a telephone call and excludes that as an electronic record. However, the state contends that the voice message is not a real-time communication. It is something that is left on a recording. It is something that someone can listen to. And again, any record created, modified, archived, received, or distributed electronically, that audio was distributed electronically and it was left on as a voice message. So I'm not going to be repetitive. The state's argument is laid out in the demurrer, and the state does have a prima facie case, and we can take this case to a jury for them to decide.
Does either attorney have any case law defining electronic record or other record as a voicemail message?
Judge, I searched extensively, and I think one of the reasons there's not is because the issue is clear. I mean, the legislature, they wrote the statute. They actually state an electronic record means, and what they're saying is everybody, police officers, everybody. This is what electronic record means. There's no case law because it's not an issue that's ever needed to be litigated, Judge. It is what it is. It's clear. A telephone call can't be any part of the combination, and I think that's why there's not any case law.
Ms. Giardina, did you find any case law?
No, Your Honor. After extensive research, there was nothing discussing voice messages and electronic communication.
Okay. I do have a couple of questions. So and I have the statute printed out, I have the jury instruction printed out as well. Florida Statute 836.10, subparagraph 1, and my question is to the state, says, which contains any combination of, and it says text, graphics, video, audio, or pictorial represented in digital form. Well, we've got audio, but when it says combination, I mean, to me, does that not imply more than one?
Your Honor, for example, when someone communicates it through a text message, it's only a writing.
Okay.
So, putting or.
Oh, I bet the court reporter can't hear you. Okay, so you may have to repeat what you just said because I don't think the court reporter could hear. Okay, thank you. Thank you.
So, Your Honor, for example, when a written communication is sent via text message, there's no combination, that's just a written communication that someone could see on their phone. If someone sends a voice note through text message and makes a threat, that would just be an audio. It doesn't need to be a video that is a combination of a graphics and audio, or writing and audio. So when the legislature lists "or," that would construe it as any one of those listed mediums in which you can convey the threat through.
All right. And then my next question is in subparagraph 2, where it says, in any manner in which it may be viewed by another person. And viewed, to me, means seen or looked at. Does the state have any comment on the word viewed?
No, Your Honor.
Judge, can you guys still hear me?
Yes.
I just wanted to make sure I didn't have some internet problem because it got real quiet. Sorry.
Oh, no, you're good. I'm just frustrated that there's no case law on this issue. And Mr. Cobb, I heard your argument of why you think there's no case law, and maybe that is, maybe that isn't, but
Can I
either
say
way,
something?
I wish there were
Yeah, I do too, Judge, absolutely. Judge, just really quick, with regards to the audio portion, when we're talking about combinations, I don't know how anybody could interpret the telephone call portion of what happened here as audio when the statute specifically excludes telephone call. Even though this was a telephone message, you had to pick up a telephone dial and speak through a telephone. If that's not a telephone call, I don't know what is. So I don't know how audio could be included. And then, of course, I focus on the part about viewing. And all I can say is that when I read the legislative history, the legislative was very concerned with, like I've said several times, TikTok, Instagram, Facebook, things of that nature. And all those can be viewed.
Okay.
Your Honor, social media is not the only medium that you can convey the threat through.
Okay.
I still don't know how we get around the second portion about it having to be viewed. The legislature did not include listen or any other type of definition. There's no really need to define view because it is what it is. Everybody knows what view means.
I really do not like to take things under advisement, because then it takes a while before I have time to circle back to it, and then, well, I think I'm going to have to take this under advisement and try to do some research on it. I know y'all told me there aren't any cases. I'm not doubting that for a minute, but essentially, the court's going to have to interpret the statute, and I'd like to have a little more time to do that and to do some research on this particular statute and look at, even if no court has addressed this particular issue, I would like to read some cases involving the statute for some guidance. So I am going to take it under advisement. So, sir, I'm not able to give you a ruling today because I want to do some more research on it.
I do have one question. Would I be able to get check-ins to where I can call instead of being.
Yeah, I'm working on that, Mr. Goff, but that's not an issue before the court today, but I'm going to get that remedied for you. I just got to get up with the state and see if they have any objections to that.
Okay.
So what needs to happen is your lawyer has to contact the state and see if they object. If they don't object, the lawyers will, Mr. Cobb will send me an order over. If they do object, we'll have to have a hearing, but they have to have more time than just today to be prepared for that. So let's set the next court date. I think, actually, you may already be set for August 10th. Let me check.
If that's the pretrial date, yes, ma'am, we are.
Okay. Yeah, I'm pretty sure that's the next court date. August 10th at 9 o'clock is your pretrial conference, so I'll see you then, okay? Thank you.
Thank you, Judge, I appreciate it.
Sure, thank you, Mr. Cobb. And
right.
I will try to get this figured out as soon as I possibly can.
Yes, ma'am, thank you.
Sure. I think I have someone else on Zoom. That must be for a hearing, actually.
Yes, Your Honor, it's Mr. Nadal's case with Mr. Medina. I believe we might be back there talking with him. It's potentially that hearing will be moot with a plea.
Okay.
I'm just waiting for confirmation from Mr. Medina.
Okay, thank you.
That is the probation officer from Ocala.
All right, so we need to call, there's been a request to call certain inmates first. And I've got Mr. Koch coming in, and I've got Mr. Gates, and I'm not sure if...
They're all Mr. Koch.
Okay, so Mr. Koch, I think there's been a request to call some of your specific inmates.
Yes, Your Honor.
All right, so whichever one...
It's Lokito Carter.
Okay. All right, this would be Ms. Laquetta Carter, 25 CF 1238, and she is present. I have Mr. Koch for the defense, and I have Mr. Ferris present for the state.
Judge, may I have a brief moment, please?
Sure.
Carter, Your Honor.
Okay, so we'll recall Ms. Carter.
Yes, thank you. Come back? I'll go right back there.
Okay, thank you.
Who would be the next one you need me to call?
Deborah Fitzgerald.
Okay. Deborah Fritchell, and just bear with me, let me get to that on my docket. All right, this will be case number 25 CF 2055.
Your Honor, I have one case left my colleagues will be covering. May I be excused?
Yes.
Thank you.
Have a good day. All right, and the defendant is present. I have Mr. Koch present.
Yes, Your Honor.
Okay, and we're here, there's already been an arraignment. It's listed as an arraignment, but I saw that a not guilty plea was entered on November 13th, 2025. And this is, Ms. Fritchell was in the mental health 90-day diversion program, and that didn't work out, so she's back on the docket.
I saw that, Your Honor, and Mr. Ferris did provide us, again, with the information. Like you stated, there's already a not guilty entered. If we could set her for the in-custody pretrial docket, Your Honor.
That would be August 12th at 9 o'clock for pretrial conference. All right, thank you.
Thank you, Judge.
Mhm.
Casey Francis up next.
All right.
Yes, ma'am.
JJ France.
All right, Casey France is next. That's 26 CF 35. And she is present. And we're here for competency status. I appointed Dr. Zeman on June 22nd, but I haven't seen a report come out yet.
That's, my notes indicate the same, Your Honor. We're still waiting on Dr. Zini's report. If we could put Ms. France on a status date, I believe you gave out September 22nd, Your Honor, at
Yes.
9 o'clock.
Well, let me ask, Ms. France, has a doctor come to see you yet?
Yes, ma'am, yeah. And we had a good conversation on the
Good.
things, and then he said he was gonna make a recommendation for a
Perfect.
program. I talked about like, going to a program or whatever.
Wonderful, thank you.
Yes.
I'm glad to hear he's already come to see
Yes,
you.
yeah.
How about if we do the August date, just in case, because if he's already come, then hopefully we'll have that report soon. So August 18th, 9 o'clock for status, and hopefully we'll have a report back prior to then.
And Your Honor, if I do get that report sooner, of course, I can advance Ms. France on the
Absolutely.
docket.
Yes, we have earlier dates if we need them.
Thank you.
Sure. All right, thank you, ma'am. And
Okay, I'll go.
does that take care of the ones I needed to call? Okay. All right, Mr. Gates, I have you and Mr. Koch present.
I think Mr. Koch needs to talk to his female, so I can handle my two.
All right. So whichever one,
It's gonna be Florentino Garza.
all right, Mr. Florentino Garza, 24 CF 1716. I have Mr. Gates present. And who do I have present from the state? Mr. Ferris?
James Ferris.
All right, wonderful. All right, and the defendant is present.
Hey, Mr. Garza. Hi. Your Honor, this is Mr. Florentino Garza before the court on a competency hearing. I met with Mr. Garza. At this point, I'm going to stipulate to the authenticity of the report from Florida State Hospital.
All right, and does the state also stipulate I can rely on the report?
Yes, Your Honor.
All right. I did review the report. It was filed on July 7th, and it is from Florida State Hospital, and it states, it's a lengthy report, and it states that Mr. Garza has been restored to competency and that he is competent to proceed, and that it is critical that he stay on his medication.
Yes.
So the court finds that the defendant is competent to proceed. I did prepare an order just in case, and I will sign that now and hand it to Madam Clerk. I do have a question, though. It's got to be sent to all these people. So here is the order finding him competent. All right, I've entered the order finding Mr. Garza competent
Yes, Your Honor.
to proceed, and we need to set a next court date?
Your Honor, would the state confirm the offer for Mr. Garza?
The offer is adjudicate 24 months prison.
And Your Honor, the court can look at Mr. Garza's arrest date, do some simple math to today. Mr. Garza's been in custody for 24 months. I think that would mean essentially that offer, if he took it, would be time served, he'd be eligible for release. If that's the state's offer, then I think Mr. Garza would like to accept that offer.
Yes, sir.
Okay, so would you mind writing that up?
Yes, Your Honor, if we can pass Mr. Garza, I'll write it up and then go over it with him.
Be aware that Okaloosa County Sheriff's Office is requesting $218.10 for transport. Let me just make sure that's the only.
$218.10.
$218.10. Let me make sure there's not another one in here. That's the only one I see,
Yes, Your Honor.
so.
So if we can pass Mr. Garza, I'll get him resolved today, and then he will be able to release pretty soon, depending on how the jail wants to handle it.
Okay, that's good. We'll recall Mr. Garza whenever you're ready.
Jordan Kimmel is up next.
All right.
Mr. Garza, check over there. Hang on, hold on to him.
Okay, Mr. Jordan Kimmel, 25 CF 1468, and he is present along with Mr. Gates.
Yes, Your Honor, we have a plea agreement to be filed in Mr. Kimmel's case. If I could get him to sign.
Yes, do you need the white noise?
No, Your Honor.
Okay.
Mr. Kimmel and I had talked about the offer. He had a question prior to signing that I answered, so 7/21/26.
Thank you.
Just counting jail all the way, okay?
Yes.
May I approach, Your Honor?
Yes,
And we have no objection to the score sheet.
thank you so much. Mhm. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you. You can put your hand down. If you'll just tell me your name, please.
Jordan Kimmel.
Thank you, Mr. Kimmel. You're here in 25 CF 1468 on allegations that you violated your probation. And I am looking at the affidavit that was filed on October 23rd, 2025. It has 10 allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes.
All right, have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the second page?
It is.
All right. Do you understand that you're giving up your right to have a contested hearing and make the state prove the allegations?
I understand.
Is anyone forcing you or threatening you?
No.
Has anybody promised you anything?
No.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No.
I have a score sheet that shows 12.6 total sentence points.
Yes, Your Honor.
All right, and Sir, are you admitting all 10 allegations that you violated your probation?
Yes.
All right, I accept your admission. I find it was freely and voluntarily made. In accordance with your agreement, the court does find that you're guilty of violating your probation. There will be an adjudication of guilt on the 3 charges that you're on probation for. It looks like it was previously a withhold adjudication.
Yes, ma'am.
Yeah.
Mr. Kimmel was adjudicated guilty of a felony in Santa Rosa, which was the subject of the violation of probation.
Right. And probation is revoked and terminated. And you are sentenced on each charge to 90 days in the Okaloosa County Jail concurrent with credit for time served. And the following additional costs are imposed. $100 cost of prosecution, $150 cost of defense. That includes the $50 application fee. You will have 24 months after you get out to pay any unpaid court costs. It says restitution. I cannot recall about restitution right now, but let me take a look. If restitution was ordered and it remains unpaid, then I see that I reserved jurisdiction. I don't see that an order was ever.
I did it in abundance of caution, Your Honor.
Okay. So if there's any outstanding court costs, restitution, fees, anything that's unpaid after 24 months when you get out is going to either go to collections or a civil lien, depending on what it is, and that'll affect your driver's license. You have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I'll appoint one for you. Good luck, sir. Thank you.
Thank you.
All right, I see Mr. Medina and Mr. Koch present.
I don't know if Mr. Koch has out of custody, but we do have some out of custody.
Okay, let's go ahead and take some of
Do you
those.
have out of custody? Yes, Your Honor, there's an in-custody person, Mr. Nadal is in custody that
We have the-
Assistant State Attorney Gaynor would like to do first because she has a probation officer that she's trying to
Yes, on Zoom.
release.
Yes.
So
All right.
could-
This will be Sean Nadal.
And Your Honor, I'm anticipating when he gets out here, him signing the violation of plea agreement that he's been over with me this morning that will lead to him proceeding directly to sentencing. The state would then be able to release the probation officer. In addition, Mr. Nadal's wife would be able to come in on the Zoom, hopefully, for sentencing.
I think I saw, I can't remember her name off the top of my
Your
head.
Honor entered the
Yes.
order yesterday. Thank you for that.
Sure.
Her name is Jennifer Cannon.
I believe,
C-A-N-N-O-N, I believe.
I saw her on Zoom earlier, but she's not there now.
Okay.
I saw her in the waiting room. All right, and I have Mr. Sean Nadal present.
Yes, Your Honor.
Thank you.
Are you ready to sign the agreement? Yes. Okay. This, you keep that copy. It's the
I'll
same.
bring in the probation officer if that's, if
Yes,
you'd
Your Honor.
like me to.
This is Nadal.
Oh, I need to sign it. Sorry. I thought this was a copy.
The probation officer on Zoom is trying to join, but Zoom has been very slow this morning. So hopefully that will happen soon. We're here in case numbers 19 CF 3479, 19 CF 3481, and 19 CF 3491.
Your Honor, may I ask a question, Your Honor?
Sure.
Just to make sure we don't have a logistical glitch on something that's important. Can I text my assistant to call Ms. Cannon to get on the Zoom?
Yes, yes, that would be fine. All right, and I believe Officer Ramirez is on Zoom. And go ahead and text your assistant about Mr. Nadal's wife.
Thank you, Your Honor.
Sure.
Your Honor, if I may address Officer Ramirez.
Go right ahead.
Hi, good morning, Officer Ramirez. Thank you for being here.
Good morning.
Hey, I am signing a plea agreement right now with Mr. Nadal. Once he signs it and the court accepts his plea agreement, if she does, you will be released from your subpoena and from testifying. I just couldn't do that until and unless the court accepts this plea agreement. It'll be a plea to the bench with a guideline cap.
Understood.
All right, so just hang out just for a little bit longer if you don't mind.
Yes, ma'am.
And I had fixed the score sheet, these points actually went down a little bit.
Okay.
It's 113 instead of 117.
So you changed it, okay, let me, Your Honor, there was a slight error in his favor that's, that the state graciously has made a change.
Sure.
So instead of a 117, it's 113.
Yes.
1-4.
Yes, sir.
And, so, okay. It's the 113.4.
Yes,
right,
yes, sir.
Instead of the 117.
Yes, sir.
And, let me change that on your copy. Beg your pardon, Your Honor.
No problem.
And Your Honor, I'm going to provide a copy to state probation as well, so that they understand what we're trying to do here. Because well, even though there's a probation officer in Marion County, that there's still jurisdiction here in Okaloosa County, of course. May I hand that?
Yes.
Thank you. Okay, so go ahead and sign there. You ready? You have any questions? May I approach with the agreement and score sheet, Your Honor?
Yes. Thank you very much. Mhm.
And Your Honor, Your Honor will see the violation of probation plea agreement involves a plea to the bench with a, I think it's 113.4 cap on DOC, and with credit for all time served, no cap on supervision. There are also going to be applicable costs and so forth, and it wasn't meant to exclude anything. I just don't typically write that level of detail in there.
Understood.
Thank you.
Sure.
And I am advised that Jennifer Cannon is getting on the Zoom right now, Your Honor.
Okay,
Hopefully she appears momentarily.
all right. It looks like Mr. Nadal has already been adjudicated guilty on all of his
Yes,
pending
Your Honor.
charges? Okay,
He was adjudicated guilty back in 2020.
okay.
And just, may I give it another little nuance?
Sure.
The court will see that he pled out to a variety of lengths of maximum incarceration. So I think basically, in the event that the court were to do a DOC sentence, would probably be doing it as to the second degree and first degree felonies, and not as to the third degree, because the third degrees, they were, it's a 2020 case on 5-year felonies. It may not be I'm not exactly sure of how that would be calculated on the 5 years, but the worst that could happen is the cap on the DOC of 113.4 under the
Okay.
agreement. And I'm sorry, Judge, to keep rambling on here, but from Mr. Nadal's perspective, he's going to be asking for reinstatement. He knows the state doesn't agree with his request, but he's asking for it, and it's going to be supported by his wife's testimony and his own.
Oh, I think that's his wife right now. Do you want me to bring her in?
Yes, Your Honor, please.
Okay. All right, it looks like Jennifer Cannon is present. All right, Mr. Nadal, if you will please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
Yes, I do, Your Honor.
Thank you. You can put your hand down, and if you'll just tell me your name.
Sean Nadal.
Thank you. And I called out the case numbers a minute ago. You're here on allegations that you violated your probation, and I'm looking at the violation report that was filed on March 7th, 2026. And
Look,
just
Papa.
pull that up.
Honey, I
It
need
contains 1, 2, 3. Looks like 4 allegations, but let me double check and make sure that I'm.
That's my understanding, Your
Okay.
Honor.
Who's the governor?
Yes, I do see 4 allegations of violation of probation. Have you had a chance to talk to your lawyer about those 4 allegations that you violated your probation and any possible defenses?
I admitted to them, Your Honor.
Have you talked to your lawyer about it?
Yes.
Okay.
Yes, based on some points that I want to address when you consider appropriate.
Okay.
I decided to own things to.
If you'll just bear with me.
Yes.
Okay,
Yes,
thank
Your
you. I
Honor.
just need to ask you some questions
Yes.
first, then I will give you a chance to
Yes, sir.
speak.
Yes,
Okay,
Your Honor.
But if we can just get through these questions. So have you discussed the allegations that you violated your probation with your lawyer?
Yes, I did, Your Honor.
Did you discuss this agreement with your lawyer?
Yes, I did, Your Honor.
Do you read English?
Yes, I do, Your Honor.
Did you read this agreement?
Yes, I do. I did, Your Honor.
Is that your signature on the second page?
Yes, it is, Your Honor.
Okay. Do you understand the rights that you're giving up by admitting to the violations?
Yes, I do, Your Honor.
Do you understand you have the right to have a hearing and make the state prove that you're guilty of the violations?
I do, Your Honor.
Do you understand you're giving up that right to have a hearing?
Yes, I do, Your Honor.
Is anyone forcing you or threatening you to make you admit to the violations?
Nobody is, Your Honor.
All right. And has anybody promised you anything to make you admit to the violations?
No, Your Honor.
Has anyone promised you a particular sentence?
No, Your Honor.
I see that this agreement says that there is a cap on prison time in the amount of 113.4 months. Has anyone promised you a particular sentence as far as you're not going to get any prison time or how much you might get other than this maximum cap, or any other type of sentence?
No, Your Honor.
Do you understand that whatever sentence is imposed is entirely up to me, subject to this maximum in your plea agreement?
I do understand, Your Honor.
Do you understand that I'll listen to what you have to say, and I'll hear from your wife as well if you wish for me to, and the state may wish to present whatever they wish, and I'll have to just listen to all of it and make a decision? Do you understand that?
Yes, I do, Your Honor.
Do you understand that the court can only deviate from the sentencing guidelines if there were specific grounds, and even then, the court would have to find that it's appropriate to deviate from the sentencing guidelines?
Your Honor, may I comment on that?
Yes.
Because he is asking for reinstatement, were the court to reinstate, then the guidelines won't control, therefore there wouldn't necessarily have to be a mitigating factor.
True.
Thank you.
But if the court does not reinstate?
Yes, Your Honor.
Do you understand?
I do understand,
Okay.
Your Honor.
Has anybody promised you that the court will reinstate you to probation?
Nobody has, Your Honor.
Are you satisfied with the services of your lawyer?
Yes, I am, Your Honor.
Did he answer all of your questions?
Yes, he did, Your Honor.
Is there anything that I have said that you do not understand?
No, not so far, Your Honor.
Please tell me if I say anything you don't understand, okay?
I would, Your Honor.
Good, all right. Have you had any drugs or alcohol or anything, any type of substance in the last 24 hours?
No, Your Honor.
All right, I do have a score sheet, as I mentioned. It has 179.2 total sentence points. Any objections to the score
No,
sheet?
Your Honor.
Mr. Nadal, did you look at your score sheet?
Yes, Your Honor.
Do you see any errors or mistakes in the charges or in your prior record?
Your Honor, I think that the state made a small change, so I am not sure exactly if he's seen that in the same level of detail he had seen the prior version. Can I have that for just a moment?
Sure.
The version we gave to the court? just so
Absolutely, I just want to make sure that
he-
everybody
Thank you.
agrees it's correct.
Yes.
And if it's not correct, let us know.
I'm sorry, Judge, I just getting the old one out to make a quick comparison. So this was the prior one we were looking at. That's the same prior. It's there, same prior one there. It looks like. Here was a. Let's see. Okay, so basically, two of the charges were reduced. I didn't know what change Ms. Gaynor was made between the prior one.
I don't, I did that about a week or two ago,
Okay.
and
I'm just doing
there
a quick.
was issues with the original score sheet, I just had to start over.
But it went, the point is that
It went down.
It went down.
Yes,
Okay,
I
so-
understand.
So that is an error. If there had been an error, it's now been corrected in your favor.
In my favor, I understand.
So we're not questioning the score sheet, because you had previously pled out with a higher.
I understand.
Okay, thank you, Your Honor.
Sure. Thank you very much. I'm looking at the judgment and sentence, and this is way back in 2021, and I am only seeing 2 cases listed, but let me
Your Honor, there was several judgments, modification, amended judgments. Some of them were uploaded in some cases and some weren't uploaded in others in the clerk site. This took me a good hour to print and basically kind of puzzle piece together between all of the cases. I do have a modification, an order of the modification of probation. I think the most recent was March 14th of 2024. I did bring a copy of that, as well as the original sentencing, plea agreement, the original guideline score sheet.
Okay, let me just look through, because I'm looking at a judgment and sentence in 19 CF 3479, and it lists all 3 cases at the top, but I only see the charges on 2 cases, so I'll have to dig into that for a second. But, so let me circle back. Mr. Nadal, did you have a chance to look at this score sheet?
Yes, I just did, Your Honor.
Do you see any errors or mistakes?
It was clarified to me that the error was fixed on my behalf. And
Okay.
it brought down 4 months of the original 117, came down to 113.4.
Do you see any errors with your prior record or the charges or anything at all?
No, they just right now told me about 2 priors that I had that's the reason that it came down. It came down 4 months. So I understand perfectly as far as they have shown me why, the why.
Okay.
And I appreciate it.
Sure. So, do you understand that if you're not a U.S. citizen, you could be deported?
Yes, I understand. I am a U.S.
That's
citizen,
fine.
Your Honor.
I have to advise everyone of
Yes.
that, so.
I understand.
So are you admitting all 4 of the allegations that you violated your probation?
Yes, Your Honor.
I accept your admission. I find it was freely and voluntarily made. And in accordance with your agreement, the court finds that you're guilty of violating your probation as alleged in the affidavit. And next, we will proceed to sentencing. There's already been an adjudication of guilt. And it looks like we're here on counts 1, 2, and 3 in 19 CF 3479, 1, 2, 3, 4, and 5 in 19 CF 3481, and then count 1 in 19 CF 3491. And regarding sentencing, does the state wish to present any testimony or argument or recommendation?
Your Honor, the state actually would call Officer Ramirez.
Okay.
Just to testify as to his recommendation for sentencing.
All right, so Officer Ramirez, if you will please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I
Thank you. And if you will please state your name.
Officer Ramirez, R-A-M-I-R-E-Z, and first name is Raymond.
Thank you.
R-A-Y-M-O-N-D.
Thank you. Go ahead, Ms. Gaynor.
Officer Ramirez, how many violations of probation has this defendant had?
In the past?
Yes.
1 second.
Can I just ask, is the state asking as to these cases or prior, like the lifetime?
The cases that we're here for today.
I'm looking at, give me 1 second. I see 2 on my violation report, ma'am.
And was he was he currently on community control when he picked up the most recent violations?
Yes, ma'am.
Is that basically considered the most stringent form of probation?
Yes, ma'am.
What would be your recommendation for this court for the defendant to be sentenced to?
My recommendation, as I listed on the violation report, would be to revoke and terminate the supervision and sentence him to incarceration as appropriate.
Thank you. I have no further questions, Your Honor.
Your Honor, can I ask a little bit of Ross?
Yes, go ahead.
Steve Medina for Mr. Nadal. Can you hear me okay, probation officer, sir?
Yes.
Thank you for your courtesy. I'm looking at the history of supervision in your report, and it seems to show that the original sentence was December 22nd, 1920 with Judge Gontarek. And then there was a February 2024 violation of probation modification by Judge Ketchel. Are those, so basically there was an original sentence and one VOP, and then this would be, the current VOP would be the second VOP, is that correct?
Because I'm seeing one violation where he would revoke back in December of 2020. Let me look into my system to see if, I believe this is the same case,
I
but.
think that was the original sentence. December 22, 20.
Give me 1 second.
Yeah, I'm looking at your paragraph 3.
Okay, so, I mean, I don't have a copy of the minutes, but based on his history, it appears he may have been revoked, but I would have to look into the court minutes to say with certainty, and sentenced to this period of supervision. But give me 1 second, I'm trying to see if I could confirm that it was this case.
I think it was a different case. I'm looking at the plea agreement. There was a VOP, according to this plea agreement, 19 CF 2832, which we're not here on that case today. Now, correct me, all of you, if that's wrong. I'm just looking at the original plea.
Yes,
Yeah.
when it looks to me, Your Honor, that when he got sentenced on December 22, the year 2020, he was also maybe revoked in another case or
Correct.
two. But that is not a VOP that's on the, basically there are 12 points for violation, and this is the second violation. That's why it's 12 points, 2 times 6. And that's consistent with paragraph 3.
Okay. All right, go ahead.
I don't think I have any other questions, Your Honor. Thank you.
I have a question. I saw in the report that Mr. Nadal it says in the report that Mr. Nadal is a violent felony offender of special concern. Is that correct?
Yes, ma'am.
Thank you. All right, so does the state have any further questions for the officer?
No further questions from the state, Your Honor. He may be released from the
All right,
state.
let me just make sure Mr. Medina doesn't have any follow-ups after I've just asked one. Any follow-ups for the officer?
Yes, I'm just checking.
Go
Your Honor.
ahead.
No, Your Honor.
Okay. Thank you, Officer Ramirez. You are free to go if you wish, or you can stay, either one. Thank you. All right, anything else from the state?
Nothing further from the state, Your Honor.
What is the state requesting?
The state will be requesting the guideline sentence, Your Honor, the 113 months state prison for all 3 cases, Your Honor. That is the lowest permissible sentence. Defendant is a violent felony offender of special concern. This is his second violation. He was on the most stringent form of probation at this point. He's already been given a chance, Your Honor, and based on the violations in the report, testing positive for controlled substance in the urinalysis, and as well as failing to answer truthfully and failing to remain confined to his approved residence. Those are the violations alleged in this violation of probation affidavit. Given that, Your Honor, the state would recommend and request this court to impose the 113.40 months DOC.
Thank you.
And also given the underlying, the seriousness of the underlying charges in this case of what he's on probation for.
Thank you. All right, Mr. Medina?
Your Honor, I wanted to correct something that I misstated on in my initial, there was a point where I interrupted the court, and I'm now looking at paragraph 3 of the violation report, and it actually corrects something that I stated incorrectly. If you look at the history of supervision, paragraph 3 in the violation report, the next to last paragraph, it says the offender was sentenced as follows. It says does Your Honor see that paragraph there?
I do.
And then I'm gonna, after I make this point, I would proceed with Ms. Cannon and so forth.
Yes.
The offender was sentenced as follows: 2 years prison for cases 19 CF 3479 count 1, which was the 15-year count. So I misstated that because that already got 2 years probation on that count. And then 19 CF 3481, that count 1 and 2, which were the first and second degree felonies in 3481, that received part of that. That's also got the 2 years prison that was concurrent. And then the 19 CF 3491 was count 1 of 3491, and then it said followed by 5 years probation, concurrent with 3 years suspended DOC sentence on all remaining counts in 19 CF blah, blah, blah. So the bottom line is, Your Honor, I'm sure that there are plenty of times that could be stacked with the third-degree felonies to come up with a consecutive sentence that was a lawful sentence that met the state's cap that the defendant has agreed to of 113.4, but how the court got there would need to be kind of meticulously stated, and it wasn't as I stated, and I apologize for my error.
Oh, no, that's, all right.
Okay, thank you. May
Sure,
I
go
proceed
ahead.
with Ms. Cannon, Your Honor?
Yes, let me swear her in. Ms. Cannon, could you please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, ma'am. You can put your hand down if you'll just state your name, please.
Jennifer Cannon.
All right, go ahead, Mr. Medina.
Ms. Cannon, my name's Steve Medina. We've never spoken before, but you have spoken to my assistant, Vicki, last week and maybe even this morning. Is that correct?
Yes.
And you live in California, is that right?
Correct.
Can you state your address in California if you know it?
Oh, give me 1 second. I'll find a piece of mail with the address. I'm in Lemoore, California.
Okay.
I'm at the Naval Air Base.
Okay, that's fine for now. Is there anybody else in the room with you? I think you have a granddaughter. Is she with you?
Yes, we're raising her together.
Okay, all right. I don't think there's any objection, but basically there's nobody else to watch after this child, so she really needs to be with you right now. Is that correct?
Correct.
I mean, in terms of while you're testifying, she doesn't have any other place to go
Honey, can you go out for just a moment? Can you go in the sala for a minute? Please?
Okay, thank you.
Thank you.
Because usually when people testify, there's nobody else there, or if anybody is, they're identified, so that's why I'm covering that. Okay, Ms. Cannon, are you legally married to Sean Nadal?
Yes, I am.
Okay, when did you all get married? And I'm sorry, I'm giving you all sorts of tests of anniversaries and addresses and stuff, but approximately when did you get married?
We got married as soon as he got out from his last violation. We got married on March 11th.
And was that of 2024?
When he was released from
Yes.
his violation last time, yes.
Okay. What do you want the court to know and consider from your perspective as his wife? Whatever you wish to say, I may have some follow-up, but you've probably thought long and hard about what you wanted to tell the court in presenting your testimony. So why don't you tell the court whatever's on your mind and heart?
Well, Number one, I understand that my husband did make a mistake. And I understand that there are consequences for the mistake that he has made. However, I plead to Your Honor to have mercy. We are raising our granddaughter together. And yes, he's faltered. He was almost done, and that's where it's even more difficult. He was almost done with probation. We were almost there. I can't excuse his behavior, but I can say as his wife, he did. It was very difficult. We did face a lot of challenges, and he was the one primarily taking care of what it was for our rent. That's why I, in turn, had to leave to come to California, because there was no way that I was going to be able to stay there and continue paying not only bills, but child care for Zaya by myself. And in Florida, not having anybody but him. We were literally without any kind of support other than each other. And while again, I understand that there are consequences, Your Honor, I ask that you be merciful. I know that my husband had proposed a plea of 5 years and with time served as credit. And I ask Your Honor if you could please consider that. He has nowhere to come home to at the moment if he was to get reinstated, because I'm not there. We were all that we had as far as each other. I had to leave everything that we pretty much built up together as a family materially, but material can be replaced. My husband cannot.
So Ms. Cannon, let me ask you some follow-up. Because in Florida, we have a procedure that the court follows that's set by the Florida legislature. And when you were, I'm sure when you were talking to Mr. Nadal, he didn't understand all the ins and outs of that. But basically, you have this child as your granddaughter. She's your biological granddaughter, is that correct?
Correct.
But he has been serving functionally as, you're basically co-parenting this child up to the time when he got arrested, is that fair?
Yes.
Okay. And do you have lawful custody of her?
Yes, I do. I've had her my whole life, but I do have legal guardianship. I've had it for years.
And is that out of California or Florida?
California.
Okay. And what is the child's name and date of birth?
Zaya Lopez.
The first name? Under Florida law, the court has something called the lowest permissible prison sentence, okay? So if he doesn't reinstate, the court is probably going to be bound by this lowest permissible prison sentence. So it's not a matter of doing 5 years less, in less than the 113 months. So put that aside, okay? Because basically it's an all or nothing proposition. He's either going to reinstate or the court is probably going to impose the lowest permissible prison sentence, okay? So you need to know that. Now, if he were to reinstate, the court were to give him another chance, do you know him enough? Have you known him long enough, knowing the relapse that he had and the kind of person he is now, even though it would be hard, do you think he should get a chance at reinstatement if the court is willing to do that?
For him to be in Florida?
Yes. Well, I mean, potentially he could pursue a transfer. If the court were to reinstate him to probation, he might have to be in Okaloosa County, because that's where this court is. And it's possible that he could pursue a transfer out of state, but because you're married to him and live in California, et cetera, I don't know how that would work, but putting aside that there are always difficulties with somebody when they come out, you know, they get released from jail, it's hard to put your life back together again. But even though it might be very difficult for him, do you want him to get that chance to get out and reestablish himself and work, or do you think the court really should just go ahead and impose a prison sentence?
Okay, so that's a very loaded question, and
Because the prison sentence, like I said, is probably going to be the 113 months, because the court probably isn't going to have discretion to cut it in half or whatever you were saying about the 5 years.
again, that's where I would plead out to the judge. The thing is, if my husband is released back on the probation, the same probation that he had, even just released, just alone there in Florida, he has nowhere to go. So in essence, you would be asking me to release him on the street and just have the hope that he'll find a place, a shelter, and then be able to comply to being able to meet all the needs of probation, and then being able to get transportation, being able to set up some kind of income for him to even get going. I mean, in a sense, I feel like the answer that I need to give, I feel like, in essence, if you're asking me to say either reinstate him or give him all these years, I feel that that's unfair. And I would lean on the judge's discretion on this, because I believe that if we just let my husband, if you put any person out on the street and say, okay, you're free, but you have to follow all these guidelines, figure out where you're going to stay, figure out what you're going to eat, figure out where you're going to go, that's unfair.
Well, if the Florida legislature has said it, though, the court may not have the discretion about fairness that you and I feel. We agree on that. But if the court doesn't have that discretion, do you have anything more to say? If the choice of the court is 113.4 months or reinstate, which do you prefer for the court, for your husband?
If it was all the option of all of those months or reinstate,
Yes.
those were the only options,
Yes.
I would say to reinstate, because, I mean, given his age, he's not 20 years old. He's not 20 years old. Every moment is a blessing. And right now, it's valuable time that I understand. He's made mistakes. And believe me, he's paying the repercussion, not just in serving time, but in the fact of losing, in essence, his home and his family. So if I had to choose whether giving my husband 9 years or giving him a chance, I would say give him a chance.
Okay. Even though it's going to be hard.
Again, I don't think I don't think that's a fair choice. I don't think that you're giving me fair.
Yeah, it's not me. Okay, do you have anything more to add to the court? To tell the
I
court?
just plead to the judge.
Okay, thank you. No further questions, Your
I
Honor.
plead to the judge to please consider the circumstances. Please consider his plea, his request for the 5 years time served, so that he can come back at least over your home without anything attached to him, and serve the rest of his days free of all this.
Thank you.
That's all.
Ms. Gaynor, do you have questions?
Yes, I've got a couple, Your Honor.
Go ahead.
Ma'am, I just kind of want to touch on a few things that you've stated. One of the things you stated is you've moved to California now, right?
Yes,
Where were you previously living before that?
in Reddick, Florida.
And are you aware of any family ties, friends, or any connections to Okaloosa County for your husband?
Absolutely none. I'm the only thing that he had there. Absolutely none.
Your Honor, could we get clarification? Was Redding, is that in Marion County, ma'am?
Yes.
Reddick is Marion County, yes.
Thank you, Your Honor.
And I think you've stated this before, if he were to be reinstated and released from the Okaloosa County Jail, he would have nowhere to go.
Correct.
Would he have any means of transportation to report to probation and
No.
be released?
He has nothing. When I tell you, we loaded up a U-Haul truck, one U-Haul truck, and loaded up what I can load and towed our car behind us. So everything, I mean, again, I said material can be replaced. My husband can't.
Are you working currently right now, ma'am?
No, not at the moment.
Would you be able to help any financial means for the defendant to either, if he were to be reinstated, to transfer probation or to pay any of his costs? Would you be able to help him financially with any of that?
I could try and get assistance for that. It wouldn't be from one day to the next, but I could work on that, yes.
But you currently have no employment as this moment?
No, I'm not employed at the moment, ma'am.
Your Honor, I don't have any further questions.
Thank you. All right, anything further, Mr. Medina?
No, Your Honor, but I would ask that Ms. Cannon be able to stay on the line in case something further were to arise.
Sure. So, Mr. Nadal, would you like to make a statement?
Yes, Your Honor.
Go ahead.
I mean, I don't really need the letter, but I have some points that I worked on, and I don't know if you have any convenience in me having the paper while I talk to you.
Your Honor, could he go ahead and be placed under oath just so I can follow up with questions if necessary?
Sure, if you'll, I think I swore you in earlier, actually.
Oh, okay.
He is under oath.
Thank you,
You're all good.
Sorry, Your Honor.
You're still under oath from when I swore you in the beginning.
Yes, I do swear that I will say the truth before God.
Your Honor, with all the respect that you deserve beforehand, I humble myself before you, exposing a brief account of the last 7 years of my life. Seven years ago, Your Honor, I was 49, and my life suddenly came to a drastic downfall. I had a well-positioned and well-paid job, which I lost, and there's where the spiral downfall started. Right after that, I lost my family. And wrongfully, I started using drugs, Your Honor. I started using drugs, losing sight of what was going on in my life, and not wanting to see it. I lost sight of reality, Your Honor. I saw that. Every single thing that I valued and that I was taught by my family, by my mother, including God values, weren't there anymore. Not long after that, I became a homeless, 24/7 fleshly addict, and I came to a point of uncertainty, despair in my life, not thinking right, moment of insanity, I would call it, in which I started to make bad decisions and taking poor choices. And that's how I ended up with very bad charges and in jail, Your Honor. I was desperate, not thinking right. I got put in jail. And in the midst of being in jail, after a few months, I cried out to the Lord. And He heard my cry. He came to my rescue and got me out of the pit that I was in. He lifted me up once again. I got sentenced right after that to 2 years prison with 1 year Phoenix Housing Inpatient Program, which he got me through it. And I was able, after 2 years prison and finishing the program, I was able to get back, little by little, back on my feet, Your Honor. I was able to put a roof under my head and maintain it. And little by little, blessing over blessing from part of God brought to me a new blessing, my family, which is here with me, Jennifer Cannon and Saya. And I was able to pay my bills, to keep a roof over our heads. I was able, even though that were very difficult money-wise times, I was able to pay all my bills on time, including court costs, and probation fees, of which out of 60 months that I had, I was able to accomplish 53 of them. With this, I don't want to insult your intelligence or try to say that everything was sunshine and rainbows. I mean, there was many stormy days too. In one of those, I took my eyes off the Lord again, and that's when I relapsed. After being clean 6+ years, I relapsed. The first thing that came into my mind at that moment was to hide it, but no, the Lord put in my heart to assume the consequences and responsibility and to own it, to seek help for it, and I did, and that's what brings me right in front of you, Your Honor. I currently have 3 months inside a program called ECLC. It's a 12-month program. I currently have 3 months. It's a faith-based mental health trauma-informed program. And I haven't caught any charges, any new criminal charges in the last 7 years, Your Honor. And that's what brings me right here in front of you, Your Honor, pleading out for you to have mercy over my sentence. And that's all I have to say, Your Honor.
Thank you. Thank you. Mr. Medina, any follow-ups?
Yes, can I follow up with a little bit of question? So you're in ECLC program at the jail. Is that program helping you?
Yes, it is. Yes, it is, very much, very much. It has helped me, first than anything and foremost, to find forgiveness and repentance for all my wrongdoings and restore my relationship with the Lord. And it's given me, I mean, many tools to cope with other kind of things that are going inside me.
And if the court were to reinstate your probation, but have a special condition that you had to stay in jail and complete that 12-month ECLC program, in jail before you got released to the street. Do you think that would help you in terms of having better coping strategies, help you with your drug problem that you've been working on for a long
Yes.
time?
Yes, I do. In fact, now that it's mentioned right now, that would be an amazing, that would be a very blessed option. I'm sure, I didn't have the chance to talk with Ms. Dana, who runs the program, about this, because I don't know if, I didn't think it was gonna be this fast, but for sure, she has the tools and the infrastructure out there to help us when we get out too. Yes,
So the ECLC program, you could conceivably complete the 12-month program in Okaloosa County Jail, and even if you were to get the privilege of being reinstated, you could continue with ECLC in aftercare.
yes, it could be like that, yes.
In fact, that might really help you on a
Yes,
number of levels.
Yes, it would, in a numerous
Is
levels.
there anything else before you get cross-examined, if the state wants to do that? Is there anything else you wanted to tell the court?
No, I just want to thank you for allowing me to speak up, Your Honor.
Of course. Yes, sir.
No
Anything-
further questions, Your Honor.
All right, any questions, Ms. Gaynor?
I don't have any questions, Your Honor.
All right, so to the attorneys, either way, it looks like I'm reading 948.06, 8E, and we'll need to make findings in writing, no matter what the outcome of this hearing is, regarding whether Mr. Nadal poses a danger to the community, since he is a violent felony offender of special concern. And there are certain factors that the court has to consider. What is the state's position on that finding? And again, this, I have to make these findings before I decide how to proceed. And it's not dispositive either of how I proceed, but the statute requires the finding.
Yes, Your Honor, just 1 second, I'm pulling that back up.
And I probably need to hear from Officer Ramirez for his recommendation on this particular question.
And Your Honor, could I reopen that while the others, or could Mr. Nadal address that?
Sure, sure.
So, Your Honor, Mr. Nadal, the court is allowing you to comment on a finding that the court is going to have to make as to whether or not, if you got released, you would be a danger to the community. Do you have anything to tell the court about whether you think you would be a danger to the community?
No, Your Honor, with all due respect, again, I don't think I have never heard anybody premeditated, or I don't have any means to hurt anybody. On the contrary, I don't know, I want to be a positive influence in the life of my granddaughter, first and most so, as I want to become a law-abiding citizen and be a positive influence in such society too. I know that the Lord works in mysterious ways, but I'm just done here. I'm just done.
Thank you, sir. Thank you.
Thank you, Your Honor.
Sure. So, Officer Ramirez, do you have any comments on the findings the court has to make of whether or not Mr. Nadal poses a danger to the community?
No, ma'am. Everything that I would have liked to said is what's included in the violation report. There's nothing really I'd like to add.
Okay. Thank you.
Yes, ma'am.
Does the state have any commentary on?
Your Honor, I don't. The nature of all of his violations haven't been anything violent in that regard. I know his first violation, he picked up a battery, but I do believe that was just later dismissed. I do not see an adjudication for that misdemeanor, so the state can't, in good faith, back behind it, but he is a danger. Although he did pick up that new offense, he was not convicted of that misdemeanor battery down south from his first violation. Then besides that violation, this violation, nothing of violence is alleged for his violation of probation. I mean, the underlying charges in and of itself are violent, some of them. So besides that, Your Honor, besides arguing the underlying offenses for what he's on probation for, that he is a danger to the community in that regard.
Thank you. So the court will enter a written order. The court will make a finding that presently Mr. Nadal does not pose a danger to the community based on my consideration of the factors. And I've considered those factors. I'll put them in a written order. So next, the court has to decide whether to restore Mr. Knoll to supervision or to revoke and terminate supervision. Those are the two choices before the court. And if I revoke and terminate, then the court is required to impose the minimum guideline sentence, which is the cap on the plea agreement. So, the underlying charges are extremely serious. One of them is a first-degree felony. That would be robbery, carjacking without a firearm or weapon. That is count 1 in 2019 CF 3481. Defendant is also charged with 3 different second-degree felonies. That's count 1 in 2019 CF 3479, burglary of an unoccupied dwelling. Count 2 in 2019 CF 3481, which is aggravated battery, and count 1 in 2019 CF 3491, burglary of an unoccupied dwelling. And then the remaining charges are third-degree felonies. Firearm offenses are included in 2 of the cases. The court also noted there was a prior case that Mr. Nadal was on probation for. That was included in the original plea agreement, and that probation was revoked and terminated when he originally pled in these 3 cases. Mr. Nadal got a downward departure when he initially pled in these cases. I have located the correct judgment and sentence. It's an amended judgment and sentence entered in, well, I found it in case 2019 CF 3481. It was entered on March 19th, 2021. It does include all 3 cases, and it includes all of the charges in all 3 cases. There was a downward departure, like I stated. And at that time, Mr. Nadal scored, he had 112 total sentence points. And he scored, it looks like 68 months prison. I'm just looking at that score sheet.
I did look at that original score sheet there. The entire offense, there was an error on that score sheet.
Yeah, it looks like there might be something missing.
I believe it was the carjacking without a weapon wasn't even listed in that score sheet. I triple checked the plea agreement, the judgment, sentence, everything like that. Looked like the grand theft auto was put on the score sheet twice, which there was only once. I believe there was an error so when that was originally pled out to, but the carjacking without a weapon was not included, which made the points change drastically.
So the score sheet was low at the time of the original sentence. The carjacking wasn't included on it. I'm looking at it right now.
Because that also would have been the primary offense, Your Honor, and it's the that.
Yeah, the aggravated battery is listed as the primary offense on this score sheet, and I don't see the carjacking on there at all. So this was the error benefited Mr. Nadal at the time, but it was a downward departure nonetheless. Even though the score was lower than it should have been, Mr. Nadal still got a downward departure. There was a violation. I understand that the state has represented that there was not an adjudication on that charge that led to the first violation. Nevertheless, Mr. Nadal was reinstated, and in fact, Judge Ketchel even removed the 3-year suspended prison sentence that was in the original sentence. So Mr. Nadal was restored to supervision in 2024 following that first violation of probation proceeding. And here we are again in 2026 with a second violation of probation proceeding before the court. The court does not have the option of downward departing and imposing a lesser prison sentence than the guidelines. The court only has 2 choices: reinstate and modify, or revoke and terminate and impose the guideline sentence. The underlying charges, like I have said, are extremely serious. Mr. Nadal got a break at sentencing originally with a downward departure and a mistakenly low score sheet because the main charge wasn't on it. Mr. Nadal got reinstated when he came before the court for the first violation, reinstated and modified, and we're here on the second violation, and the court finds that Mr. Nadal has been given opportunities, and the court is not inclined to reinstate and modify. The court is revoking and terminating probation in all 3 cases. There has already been an adjudication of guilt in all of the charges. The court is going to impose the following sentence. On case number 2019 CF 3479, count 1. $113.4 months state prison.
May I, Your Honor?
Yes.
I hate to interrupt. This is the point where I wanted the court to be aware that my understanding, and again, it is very confusing when you have multiple cases and pieces of paper and so forth, but I think the history of supervision, paragraph 3 on page 2 of the BOP report does clarify that he's already received a prison sentence on count 1 of 3479 and on counts 1 and 2 of 3481 and on count 1 of 3491. So I respectfully concerned about the lawful nature of any further prison with respect to those counts, because I think the probation that followed was on the remaining counts in 19 CF 3479, 3481, and 3491, all of which were third-degree felonies with max incarceration of 5 years.
So the court cannot impose prison on the charge?
That's the defense position, Your Honor.
What is the state's?
Because there was already 2 years prison on those, and the probation that followed was only on the third-degree felonies.
What is the state's position?
Let me look at my order. I don't think anything reached its maximum, so I believe the court still has jurisdiction to impose DOC.
I'm looking at the original probation order, and it is on all of the charges. Let me look at the judgment and sentence. Prison was imposed on the second and first degree felonies. That was 2 years on each of those. And then it just says, followed by a period of 5 years of probation. And then the probation order is entered on all of the counts, including the ones with prison. Sorry. So, what is the state's position?
Your Honor, he did 2 years on the you said on the first and second degrees. He still has, I mean, the first degrees are punishable up to 30 years. So he still has time remaining that the court can impose on the violation of probation. So it's not like he's met his exposure on those.
Mr. Medina?
I apologize, Judge, I don't have necessarily all the paperwork, but I'm looking at the amended judgment that was entered by, I think it was Judge Gonteric back in 2020.
Yes.
And I just want to make sure I'm looking at the same thing the court is.
Okay.
And I apologize, and this is the most inopportune time to have used two-sided paper years ago when this was copied, but where does it say that further, what leads the state or the court to, I apologize, Judge, but I want to make sure I see where the probation was actually in place, because it looks like it was only, I thought it was only on the third degree felonies, which is what the VOP report says.
I'm looking.
So that although the amended judgment covers all the cases, I thought that the prison was only, I don't think you can come back later and add years to a prison sentence when it's already been imposed on a case, unless there's some sort of express reservation on that, and I think the probation was only on the third degree felonies.
I'm putting the original plea agreement on the screen. This was the original plea agreement. And it had that other VOP case, 19 CF 2832, on there. And then it has the 3 cases we're here on. And then this 19 CF 2832, we're not here on because it was revoked and terminated. And then this is the, where it says new law cases on page 1, it's the sentence on the 3 cases we're here on today. And actually, I see that, part of the plea agreement was a lesser included offense on a couple of them, a couple of the charges. And it says 2 years concurrent DOC, and it lists the counts that are the first degree felony and the 3 second degree felonies. Then it says followed by 5 years concurrent probation with 3-year concurrent suspended DOC sentence on all counts. And then it lists the case numbers. And then I have the probation order also right here. This is the probation order. And it has that other case, but probation, there was a later order that revoked and terminated probation in that other case that we're not here on. But it has all of the counts listed and all of the cases we're here on. And it says 5 years probation.
Could your Honor go down just a little bit to the next page, just to
Sure.
see, I'm sorry, Judge.
No, that's okay.
Okay, I do see where the where the court is referencing. So the probation, does appear there was a good discrepancy from the violation report from what Your Honor is reading in the actual order.
Yeah.
But on the amended judgment, I don't know if it was, then we get into terminology of order versus judgment.
Yes.
I don't know if the judgment said the same thing.
Here's what the judgment says. I've got the amended judgment.
Yes.
And it has all three cases and all of the charges listed.
Right.
Then on page 2 is costs, page 3 is fingerprints, page 4 is the amended sentence, because the one I looked at first was missing one of the cases.
Yes.
So it says 2 years prison, and it lists the counts. And then it says followed by 5 years probation, and it doesn't specify only on certain counts.
Right. Could Your Honor go down to the next page just to make sure I don't miss anything?
Sure. Oops.
Sorry.
Uh-oh. Wait a minute. Okay, so I was on page 5, or no, I was on page 4. That was the amended sentence. Then the next page is just special provisions about, if there were any enhancements or designations, and none of that applied, mandatory minimums. Then,
Okay.
yeah.
Yes, yes, Judge, so this is a very complicated record, and I can't argue with what the court stated then.
Well, I go back to the plea agreement.
Yes.
That was the original plea
Right.
agreement, and it states
It did not
5 years.
break out the,
Well, it says followed by 5 years concurrent probation with 3-year concurrent suspended DOC sentence on all counts in all 3 cases. So when it says all counts, that tells me it's
all counts.
all counts.
I understand, Your Honor. Thank you. I apologize for
No
the-
problem.
I just wanted to be sure. Thank you.
I agree. I want to make a legal sentence, so, not an illegal one. So, is it still the defense's position that I can't impose?
I think based on what the court has showed, I can't maintain that position anymore.
Okay.
I apologize.
Oh, no, let's, I
Misstated,
want to get it
because
straight.
it was confusing based on the violation report. Thank you.
And I want to get it straight, and I appreciate you bringing it to my attention so that I can make sure that I
Yes,
check
yes.
everything, because I don't want to impose a sentence that would not be legal. So as to count 1 in 19 CF 3479, the court will impose the guideline sentence of 113.4 months with credit for time served. So, sir, you will get credit for the time that you've already served on that count. On the remaining 2 counts in 2019 CF 3479, they're both third-degree felonies. The court imposes 60 months prison on each of those. All counts concurrent with credit for time served. I don't know how much credit there will be. I know that there's the prior prison on the first count, but then there's jail credit on all the counts as well, but that'll be factored in and calculated by the jail and the prison. Then, 2019 CF 3481, as to counts 1 and 2, the court imposes 113.4 months state prison with, of course, credit for all time served. The remaining 3 counts are third-degree felonies. Each of those would be 60 months state prison, all counts concurrent, all with whatever credit you're entitled to on each of them. Then in 2019 CF 3491, it's a second-degree felony. There's only 1 charge in that case. That would be 113.4 months state prison with all of the credit that you're entitled to. All cases, all counts are concurrent with the appropriate amount of credit for time served that Mr. Nadal is entitled to in each case. I know the credit's going to be different on different charges. So, obviously, he would be entitled to the prior prison credit on the charges he served prison time on. The court imposes the following costs and fees. In case 19 CF 3479, Okaloosa County Sheriff's Office has requested reimbursement for transportation in the amount of $259.20. That's imposed. In each case, there is a $100 cost of prosecution fee that would be imposed. That's in addition to any previously imposed fees or costs. In each case, there's a $100 cost of defense fee that's imposed. And then in 19 CF 3479, there's a $50 application fee. All costs will go to collections, anything that's not paid. Did I cover everything? Let me check with the attorneys and let me check with probation, make sure I did everything that they need me to do as far as announcing, revoke, and terminate in all three cases.
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, to Officer Ramirez, did I cover everything from your point of view?
Yes, ma'am, as far as I can tell, yes.
Okay, thank you, and let me check with Madam Clerk and make sure I haven't left
Thank
anything
you.
out. Okay.
Your Honor, could I ask one other thing?
Sure.
If the defendant prefers this, would the court consider requesting DOC to place him in such prison that would provide drug treatment, counseling?
The court will recommend, I can't require. Yes, sir.
Could you recommend a faith-based center?
Yes, I can recommend it, but I can't require it. But I would hope that all facilities would have programs like that.
Thank you, Your Honor.
Sure. Yes, sir. Sir, you will have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you, sir. Thank you.
Thank you. May the Lord bless you, Your Honor.
You too, sir. Thank you. So it is noon. I know we have a couple of people, excuse me 1 second. All right, so we're going to try to, we've had a request to take a couple of inmates specifically, and we're going to try to take care of everybody who's in the courtroom who has a pending case before we break for lunch. So, Mr. Gates?
Yes, Your Honor, this is Mr. Florentino Garza. We're recalling him.
Okay. And defendant is present. This is 24 CF 1716. This is...
This is right, of course. Yep. This is what I'm paying, right?
Yeah, you'll be 24 months to pay.
Not that right there.
No. Yes, Your Honor, I was trying to see if the state would stipulate to Mr. Florentino having that credit in. The clerk's website, the jail website has him booked in on July 20, 2024, still in custody, meaning at this point he's got 24 months in, which is the state's offer. I'd rather him be released today versus having to wait weeks for the judgment sentence to be filed with the jail.
Okay, so did y'all,
The state is telling me that they can't, they won't stipulate to it, Your Honor, so I just want to put on the record that the jail's website has Mr. Garza listed as in custody date of July 20th, 2024. The offers 24 months DOC. That was 24 months day for day as of yesterday.
okay,
And we have no objection to the score sheet, Your Honor.
okay. Thank you very much.
Your Honor, based on Mr. Gates' representation with respect to the credit for time, I don't know what the credit is. If Mr. Gates is representing that it's 24 months, then the state will stipulate that it's 24 months.
Okay,
Thank you, Your Honor.
sure. Oh, I think Mr. Ferris needs to sign this. And one other thing, there is an Okaloosa County Sheriff's Office
I
request.
had it written down, Your Honor, and I completely forgot to put it on there.
That's okay, you want to add it on here? I've got it,
We talked about the other, Your Honor wants to write that on there. Mr. Garza has an objection to that.
okay, I'll let you write it on there if you don't mind, just to be sure.
It's the cost of transportation of $218.10, okay.
Okay.
That'll be due during those 24 months.
Yeah, I'll take care of it.
I know you. Thank you, Your Honor.
Thank you very much.
No, hang on here. She's gonna ask you in there.
I'll change it. Madam Clerk tells me the court costs are $867, so that saves Mr. Garza $100.
Yes, Your Honor. I apologize for that.
No, that's a benefit to Mr. Garza, so it'll help with some of that cost of transportation. So let me make sure, is there a stipulation that Mr. Garza has in fact served 24 months?
Based on the representation from Mr. Gates, Your Honor, there is.
Okay. I'm just gonna write that on here. I'm writing on the score sheet for Mr. Garza that there's a stipulation that he's already served for 24 months.
Thank you, Your Honor.
Sure. I hope so, but I don't know. Maybe. I wrote it on there, on the last page and everything, but I don't know. Okay. All right, and this is Ms. Carter, and let me just, that's 25 CF 1238. We are recalling Ms. Carter. She's back before the court.
Yes, Your Honor. My client will be admitting, and we have a form signed by all parties and a score sheet, if I may approach, Your Honor.
Yes, yes, thank you. Thank you so much. All right, Ms. Carter, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
Yes, ma'am.
Thank you. You can put your hand down if you'll just tell me your name, please.
Laquita Carter.
All right, ma'am. And you're here in case 25 CF 1238 on allegations that you violated your probation.
Yes, ma'am.
I'm looking at the affidavit filed on March 18th, 2026, and it has 4 allegations that you violated your probation.
Yes, ma'am.
Have you had a chance to talk to your lawyer about those 4 allegations?
Yes, ma'am.
All right.
Yes, ma'am.
Do you understand the rights that you give up when you admit to the violations?
Yes, ma'am.
Do you understand you have a right to have a contested hearing? In fact, that's what we were scheduled for today, and you're giving up that right?
Okay, yes, ma'am.
Oh, do you want to have the contested hearing, or do you want to,
I don't know what that means.
like a trial? But it's a judge trial, essentially, a hearing where the state proves the allegations, and I hear evidence, I have to decide whether the state has proven that you violated?
Oh, no, I want to do this. Yes, ma'am.
Okay.
Yes,
So you understand you have a right to
Yes,
have that
yes.
hearing, but you're giving up that right?
yes, ma'am. Yes, ma'am.
Okay,
Yes.
okay. And is anybody forcing you or threatening you to make you admit the violations?
No, ma'am, no, ma'am, no.
Okay, has anybody promised you anything to make you admit the violations?
No, ma'am, no.
All right. Are you satisfied with the services of your lawyer?
Yes, ma'am.
All right. And have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
Okay. Are you admitting all 4 of the allegations that you violated?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily
Yes, ma'am.
made. And in accordance with your agreement, let me just look at, there's already an adjudication of guilt. The court does find that you're guilty of violating your probation as per your agreement, and probation is revoked and terminated. And on each count, you are sentenced to 9 months in the Okaloosa County Jail with credit for time served. The court imposes the following additional costs and fees: $100 VOP cost of prosecution fee, $100 PD fee, $50 application fee. The counts are running concurrent. There are 2 counts, and that's what you're on probation for, and those are concurrent with credit for time served. You do have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you.
Yes,
Good
ma'am.
luck, ma'am.
Yes.
Thank you.
Thank you, Judge. And if we get a year, Your Honor, to pay all outstanding costs,
Oh, yes,
please.
1 year to pay costs.
Thank you, Judge.
Sure.
Thank
Let
you
me
so
put-
much, sir.
Right.
Okay.
Best of luck.
That's after release.
Thank you, Judge.
Thank you. so I think I signed it. Yes, I did. Thank you. Okay, so I believe there are some people who are present who
That's right.
are not in custody. Do I have Roy Alston present, Alston? Come on up, this is 23 CF 1200. Yes, sir, are you Mr. Alston?
Yes, ma'am.
Okay, thank you. So you're here on allegations that you violated your probation, and the allegations are court costs and cost of supervision, and I'm about to ask you if you would like me to appoint a lawyer, but I thought I better check with probation first to see if if anything has been resolved in the meantime.
No, Your Honor, it has not.
Okay, so, okay.
I do see the court costs were paid, Your Honor, on July 10th, but I did confirm with probation this morning that the cost of supervision is still outstanding.
Okay, so let me confirm with Madam Clerk that the court costs have been paid. I see a payment, I just want to confirm. And we're here in case 23 CF 1200. Well, that resolves one of the reasons we're here today. So what is the state's position regarding the other allegation?
Your Honor, I know he's not represented, but the state would inquire as to how long or if the defendant is intending to pay the cost of supervision. If he is, how long it would take for him to pay that. Because if the cost of supervision is paid, the state would be inclined, after full payment, to dismiss the violation of probation.
Okay. Sir, you're entitled to have a lawyer represent you. If you want me to appoint one for you, I absolutely will.
And maybe there's a friend of the court here.
Sure, Your Honor.
And Mr. Koch,
He's paid his court costs, it's just cost of supervision, outstanding.
That's it.
I just want to know.
Oh.
Yeah.
Absolutely. Yeah, if I could just step in briefly, Your Honor, just a friend of the court.
Your Honor, is there any objected way it costs supervision?
let me check with the state and with probation.
No objection from probation, Your Honor.
Your Honor, I don't object either based on probation's position.
Your request to waive the cost of supervision is granted. Probation doesn't object. I'm waiving cost of supervision on that basis. So let me check with Mr. Doobie if that resolves everything we're here on today. I believe it does, but let me just make sure.
Your Honor, the only outstanding balance will be $31.20 of the drug testing fee.
$31.20 for drug testing fee? Yes, sir.
I never took a drug test since I've been on probation.
Okay.
That's a mandatory fee that gets charged to everybody on probation.
Okay. I don't have the ability to waive that one.
Okay. How much is it though?
$31.20.
All right.
So what I can do is reset the case, give you a little bit of time to pay that. Is it something he can pay online?
We can pay it right now.
Yeah,
Okay, why don't we do this?
It can be paid on correct pay on that app.
Do you
That-
have,
That's another thing. The problem that I've been having with the whole payment situation, when I first got put on probation in August, right? I was told by my first PO that I guess the system y'all had online, there'd been an issue with it. And then by the time I got to my third PO since I've been on probation, I heard the same thing. Now, when I got the fourth PO, that's when I was told something different, and I had to call the clerk of court because when they gave me the court thing for me to look it up, they didn't give me the whole number like it was supposed to be, like it's filed on the paper. So when I had talked to the clerk of court told me the information they gave me was wrong. So not just with me, I'm just saying the statement when it comes to anybody else after me. There's a situation with the cost and pay that needs to be explained a little bit more better. That's all.
So do you have the ability to pay that $31.20 today?
Yes, ma'am.
Okay, you want to have a seat? I'll call another case. You take care of it, show Officer Doobie, and then I'll call you back up?
All right, no problem. Thank you.
Okay, we'll call you right back up.
Your Honor, I know Jonathan Boyd's in the audience.
Okay, let's call Mr.
And
Boyd.
there's also another, I think, a pro se request
Yes.
person too. I don't, but could I get Mr. Boyd because he has medical issues?
Yes, yes, let's
Are you
take
okay
Mr.
with
Boyd.
standing?
He's present. This is 25 CF 2044. Mr. Boyd is present, and we're here on a status update.
Your Honor, I've discussed with Mr. Boyd and looked at his medical paperwork, and I know that the expectation was that when he came before the court for this status conference, that he would have a hard and fast date for his surgery. He has some serious surgery. Apparently, DaVita is his provider, and they have a letter to whom it may concern. Mr. Boyd is currently treating for chronic hemodialysis 3 times a week. He is waiting on permanent dialysis access surgery, which needs insurance approval. The process will take up to 8 months. It's signed. I would like to file it with the court. I know it's not the news that the court and the state would probably want to have, but this is the life of somebody who's dealing with an insurance provider. It's literally in writing. Can I offer this as Defendant's Exhibit A?
Let me see what the state says.
Your Honor, may I approach with it?
Yes, yes.
Could we have it admitted as Exhibit A?
Sure, let me take a look at it if you
Sorry.
mind. Oh, no problem. Okay, thank you. Okay, so I'm handing the letter to Madam Clerk. Okay.
Your Honor, in addition to the kidney-related, very serious matter, he also has paperwork from Retina Specialty Institute where he may need to describe this, because if we're getting into some more complicated medical paperwork, could he briefly describe what his retina situation is? It probably doesn't extend beyond that kidney-related date.
And no offense, I don't need to know that.
Okay.
Because the issue is the kidney, the access surgery, that's what we're waiting on, so I don't need to hear about the
Okay.
retina.
Okay, thank you.
So, we need to schedule another date, or what's the state's position?
Your Honor, I guess we would just need to set another status date. According to that letter, it said it may take up to 8 months or so to schedule or get the surgery set. I would just like the court to order the defendant to, if that comes back within 6 months or 4 months, to notify his attorney and this court that, of when that surgery is scheduled. Because it may very well be sooner than the 8 months, and I don't want us to wait 8 months if he gets confirmation next week.
Okay, so I do want to make sure, are you still checking in with, pretrial services is still involved, correct?
Yes, ma'am.
Okay, thank you. So you need to remain on that, follow those conditions. Those are still in effect in the meantime. When would you like to reset? In a month, 2 months?
2 months, Your Honor.
Okay.
Your Honor, I got a question.
Sure.
No way I can work.
What now?
No way I can work.
Are you asking if you can work?
Yes, ma'am.
Why wouldn't you be able to work?
Your Honor, he's on house arrest.
Right, but-
And Basically, probably it could be clarified that it's house arrest subject to approved work exceptions, and we could just have a minute record
Yes.
saying subject to approved work exceptions. So if you get a work schedule, you have to get it approved on a regular basis prior to leaving the house to go to work.
Yeah.
And they can approve a work schedule. Would that be?
Pretrial services would have to verify that. So if you get employment, or let's say you have a job interview, check it out with pretrial services first. Tell them where you're going, where your interview is, get permission to go, and then go. If you get a job, tell pretrial services, I got a job, show them your schedule, you will be approved to go to work.
Yes, ma'am.
So, but you just got to clear everything with pretrial services first and
Yes,
provide
ma'am.
them your schedule in advance. So then you go straight to work, come straight home. Okay?
I have a cell phone involved, and I've been trying to get my cell phone back. It was taken at the arrest.
That is, I can't address that issue today.
That would be between Mr. Medina, we can send a proposed order, Your Honor.
Okay. So do I need to enter
Because he's already pled, Your Honor, and we're just awaiting sentencing, I think we could get property released. So I will prepare an order directing the
That's
sheriff's
fine.
department to release the phone.
That's fine.
Okay?
So y'all send me a proposed order if y'all agree on that, and I'll sign it. Then do I need to enter a written order regarding the work situation, or is that just
I think it can be a minute record, Your Honor.
Okay, as long as it's in the clerk's minutes that, as long as Mr. Boyd gets approval in advance from pretrial services and provides his schedule and follows the rules, then of course, you can work, sir. We would encourage that. So, anything else? Let's set a next court date, if not. That would be September 22nd. At 9 o'clock, status of surgery. If, Mr. Medina and Mr. Boyd, if you find out something before then,
Excuse me. Let me get a piece of paper to write it on, Your Honor.
okay. If you find out something before then,
May I
Then-
approach and see if they have one of those date documents?
Sure.
Sorry.
but if you find out something before then, if you get word on the surgery before then, sir, please let Mr. Medina know. We can get you in sooner so that you can go ahead and get that done, okay?
Yes, ma'am.
All right.
We don't have the paper, so I'm just gonna write it down on a random piece of paper, Your Honor.
Okay.
9/22/26 at
9/22,
9 a.m.
September 22nd, that's a Tuesday.
We're good.
9
Okay.
o'clock.
Got it?
All right, stay in touch with Mr. Medina and stay in touch with pretrial, okay?
Yes, ma'am. Thank you.
Thank you.
Thank you. Good luck. Thank you, Your Honor.
Sure. And I believe I have Tiffany Bracken present.
Your Honor?
Yes.
If I might, I have a probation officer for a DOB evidentiary that I think is going to be pleading.
Oh,
I'm just trying to get her out of here.
oh, okay.
That's actually.
Well, should I go ahead and take Ms. Bracken's case first? And which one?
Officer Johnson's ready to go, so whatever case she has, the court may wish.
Go ahead, and if you get that person teed up,
Yeah, do you want to take her first?
I'm going to take Ms. Bracken first while you get the inmate.
Yeah, please.
Okay, Ms. Tiffany Bracken, 24 CF 942. She is present before the court, and Ms. Bracken, let me find your motion.
I've got a copy of it right here.
Oh, I have it, I printed it out and brought it with me. So you're here on your motion for early termination
Yes,
of-
ma'am.
of probation. Let me pull up your case, and then we'll see where we need to go from there. Okay, let me swear you in. If you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you. You can put your hand down. If you'll just state your name, please.
Tiffany Danielle Bracken.
Thank you. So it looks like you were placed on probation. You pled to 24 months of probation on April 22nd, 2025. And then there was a violation And you pled on November 18th, 2025, and there was a reinstatement and modification. And let me just find that. And you were able to maintain the withhold adjudication at that time. And then you filed this motion on June 12th, 2026. And it states on here that the probation officer does not object. I reached out, or had my office reach out to the state, and there's an objection, I believe, so that's why we're having a hearing. So what is the position of the state?
The state would object to an early termination of probation. At this time, she was previously violated for 8 different violations that she admitted to, was reinstated, kept her withhold of adjudication at that point. The state does not agree with an early termination with someone who's previously VOP'd and with that many violations, and with given the ability to keep a withhold at that time. It's so based on that, the state would object and request that she just stay on her probation till her termination date.
All right, and does probation have a position?
Your Honor, just a review of her file. She's being supervised out of another office. It appears that all monetary obligations have been fulfilled, and she's current on her special conditions. Normally, probation would take the stance that if there's been a prior violation, that we would not recommend early termination.
All right, and ma'am, would you like to say anything?
My probation officer, she agrees. I mean,
Okay.
I'm just ready to get off of it.
Anything else you'd like to present? No? Okay. Well, in light of the fact that there's been a violation.
Well, I didn't have anywhere to go then, and, I mean, it really was out of my control. And, the guy that I was with, he just bailed out on me, and it wasn't really fair to me, but, I mean, I haven't messed up or anything, and I haven't failed any drug tests, and I've paid off all my court costs, and I appreciate
You doing that. In
It's
light
just kind
of,
of holding me back from doing other things, you know, because I can't go out of state and stuff like that.
well, if you were to request permission from your probation officer, a lot of
I
times
know.
they'll send me
Yeah,
something to sign, and I routinely will grant permission when it's spelled out by the probation officer of, you know, the travel and the dates and where you're going and all that. I approve those all the time
yeah.
for people.
Okay.
So, so there has been a previous violation. You did keep your withhold adjudication, which that's a concession right there. Typically, when somebody violates, there's a, you know, if it's up to the court, I typically adjudicate people, but there was an agreement in this case that you could keep your withhold adjudication, and you were restored with some special conditions. But on that basis, I am denying the motion at this time. So,
Okay.
so you'll continue on probation. I encourage you, and I thank you for taking probation so seriously since you've been restored to probation. Thank you for that.
Okay.
Thank you. All right.
Judges, Mr. Gavin Fleischman in 25 CF 640. And if I may provide a misdemeanor case number also.
Okay, let me get to the case in my docket. All right, this is 25 CF 640, and,
You want to sign it?
okay, you said there was a misdemeanor as well?
Yes, Your Honor, it is 25 MM 3143. And that was 25 MM 3143.
Okay,
721. Do you have any other questions? Okay, I'm going to provide this to the judge. She'll go over the terms and that'll be it. Yes, Your Honor, thank you.
Okay,
I have a
thank you.
signed plea form in front of me and a accompanying score sheet if I may approach. Your Honor.
sure, thank you. Thank you so much. So is the misdemeanor a VOP also?
It is, Your Honor.
Okay, thank you. All right, Mr. Fleischman, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you. You can put your hand down if you'll just tell me your name, please.
Gavin Fleischman.
Thank you. You're here in case 25 CF 640 on allegations you violated your probation. And I am looking at the affidavit that was filed on February 19th, 2026. And it has, actually it's an amended affidavit. It has 4 allegations. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes, Your Honor.
All right, and then in 25 MM 3143, it's alleged you violated your probation in that case as well. Have you had a chance to talk to your lawyer about the allegations in that case?
Yes, Your Honor.
All right. Have you discussed this plea agreement with your lawyer?
Yes, Your Honor.
Did you read and sign it?
Yes, Your Honor.
Okay. And is that your signature on the second page?
Yes, Your Honor.
Do you understand the rights that you give up when you enter a plea
Yes, Your Honor.
or an admission to a violation?
Yes, Your Honor.
Do you understand you have the right to have a hearing and make the state prove that you violated?
Yes, Your Honor.
You understand you're giving up that right to have a hearing?
Yes, Your Honor.
All right. Is anyone forcing you or threatening you to make you admit the violations?
No, Your Honor.
Has anybody promised you anything?
No, Your Honor.
Are you satisfied with the services of your lawyer?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
All right. I have a score sheet, and it shows 48.2 total sentence points. Any objections?
No objection from the defense. Your
All
Honor.
right, looks like a lowest permissible prison sentence of 15.15 months. All right, sir, are you admitting all of the allegations that you violated your probation in both of these cases?
Yes, Your Honor.
I accept your admission. I find it was freely and voluntarily entered. And in accordance with your agreement, probation is revoked and terminated in both cases. There is an adjudication of guilt in both cases. I see that there wasn't one previously in the felony case. I don't know about the misdemeanor, but nevertheless, there's an adjudication of guilt on the charges in both cases. In case 25 CF 640, you're sentenced to the guideline sentence of 15.15 months state prison with credit for time served. In addition to any prior previously imposed court costs and fees, the court imposes the following: $100 cost of prosecution fee, $100 PD fee, $50 application fee. And how long after Mr. Fleischman gets out would he have to pay?
Could we get a year, Your Honor?
Sure.
Thank you.
So after you are released, you'll have 1 year to pay all of your outstanding costs. This will apply to both cases. And then they'll go to collections. Then in case 25 MM 3143, there's an adjudication of guilt if there wasn't one already, and you're sentenced to time served, probation is revoked and terminated. The court imposes the following fees and costs on top of anything else previously imposed. $50 VOP, cost of prosecution fee, $50 defense, and both cases are concurrent. So good luck to you, sir. You have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck, sir. Thank you.
Yes, Your Honor, appreciate it.
Does that take care of all, oh, we do have Mr. Austin still present. Okay. So, was that the case you're here on, Officer Johnson? Have a good afternoon. So,
He said he's still trying on the app. He can't
It's not
get in
getting
it
the
yet.
code, or the email to get the, thing, the process approved.
okay. Well, why don't we take a lunch break and come back? And then, yeah, that way, you know, you might, once you get out of the building, your Wi-Fi might work better, it might come through. So it's 12:42, why don't we come back at 1:45? Does that work for everybody? Okay, and then we'll finish up the docket. Thank you all.
All rise, please.